Good morning, good morning, good morning, good afternoon. Because also good afternoon, good afternoon. Law nerds, it's July 1st. I don't even know how we got to July, but we're in July. So here we are, and we're going to court today in, well, a new court, but a familiar court, but a new judge and a new courthouse, but a state we've visited before. Because today we're back with Alex Murdaugh, because of course we are. We are going to be checking in with the very first status conference of Alex Murdaugh Part 2. South Carolina versus Alex Murdaugh. Now, remember, Alex Murdaugh's murder conviction was overturned on appeal based on Courthouse Becky. We have been covering that for actually literally years at this point. So we have covered the Courthouse Becky of all of it. He is still in custody on his federal cases and on his state financial crimes cases. He is only being retried on the murder and the subsequent weapons charges that went along with the murder charges for his wife, Maggie Murdaugh, and son, Paul Murdaugh. So new judge, who dis, new courtroom, and I have not watched any of this yet. It has been a wild couple of days for me. It has been it has been a lot. We'll talk about that real briefly, and then we're going to go to court. I hope that I will be able to stream tomorrow. Dr. B has some appointments to take care of his back, so I am not sure exactly when I will be streaming tomorrow. The days have been a little bit fluid. Thank you for your just kindness, understanding, and well wishes. Dr. B will be fine. It's just going to take a little bit of time. So it's just going to be a lot of medical appointments and waiting for things to get approved by insurance. Because isn't that delightful? Isn't that always fun? It's great. Waiting on MRIs and stuff is always a lot of fun. But you know, we will do what we can do. So it is a lot when mobility is impacted by back injury. It is just such a bummer, but I am glad to be back. I'm glad to be with you for a few hours, and it's been much. It's been much. So now that Dr. B is settled, we can stream for a little bit, and we are good. But it is a lot. It's going to be fine. It just takes time, right? What are we going to do? It just takes time. And back pain is something I am an expert at. So, Dr. B is in good hands, but it also means things are very busy here. So are you ready? We're going to roll the intro. We're going to do the briefest road so far, because we kind of just did. I was going to move my stand desk, but it froze. So it's just paused, and we will chat when we get to Q&A, because I do want to get to this hearing. I have not seen it yet. I'm curious about the new judge that has been appointed in the Murdaugh case. I'm curious to see what Poot is Putin, what Jim is doing, what we've got from the prosecution side with Creighton Waters et al. I'm very curious. This hearing is from June 29th. I have not seen it yet. It has been incredibly busy last couple days in the Life Day EDB. And I am going to be catching up on all of the other hearings that have happened and hearings that are happening today. So for anyone who's like, but EDB, I know. But EDB, what about? I know. Here is what I have spent my energy on in the last few days. Dr. B, who has needed some care, and going to see Travis. That is it. If you would like to hear my thoughts about DCI and the Cavaliers, I can tell you that. If it's like, but EDB, what about? I don't know. There's a hearing today in the Karen Reed case. We'll catch up with it tomorrow. There are other things going on in the Corey Richens case. I'll catch up with you guys in the app. We're going to be doing all the things. So are we ready? A lot of you have asked about my shirt. We'll get there. All right, guys, we're going to roll the intro. We're going to chat briefly. We're going to go to court. We're going to go to court because I want to see. I'm real curious about what's going on in South Carolina. I want to know all the things. I think you do too. All right, let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Mia Mo said, EDB broke Dr. B. No, Dr. B broke Dr. B. EDB has just been here helping hubby get around. He is walking a bit better today, but when mobility issues are an issue, it kind of upends everything you've got going on. Dr. B hurt his back. It is just going to take a little bit of time. We are waiting for some imaging. I am optimistic because it just is. So, you know, there's things that you do as you get older and you have the audacity to do things like bend forward or sneeze or, you know, whatever it is. And then all of a sudden you're like, crap, now I can't move. So the audacity of not being able to just do the things you used to do. So with that, we were out to see the Cavaliers. And with getting to see the Cavaliers, it was lovely, other than Dr. B getting injured. I think that he will be fine. It's just going to take some time, as these things do. So, you know, it is the audacity of sneezing. I know all of you who have sneeze-related injuries. Yep. Sleep-related injuries are a thing. Yep. And all of it. Ellie B said, can we skip Murdaugh and talk Canton drama? So many of the law nerds have needed a break from Canton and Massachusetts that today we are going to Murdacity because everybody has asked, well, many of you have asked, can we please have a break from Karen Reed? So today is a balance of, yes, there is so much going on, but also we need to shift gears just a little bit, and that'll give me time to get caught up. Don't worry, we will get caught up on everything going on in Karen Reed. Is it going to slow down? No. Is it going to go away? No. Are we going to get caught up on it? Yes. Today we're going to catch up on Murdaugh. Don't worry. And so with that, yes, I'm wearing my Lost Boys shirt. Yes, it is a tour shirt for the Cavaliers this year. I think it's fire. I absolutely love it. I enjoy the show. I will watch the show more. I have been watching replays of the show because it's very hard for me for the first couple shows to not just watch my kid. And I can't wait. I can't wait. I love the music. I am an enthusiast, so I am never going to be critical of most things. I am an enthusiast when I go to enjoy DCI. I am going to enjoy all aspects. There are times when I'm sitting there going, ooh, okay, that flag ensemble is not as ideally in unison as one would hope at this point, but I'm sure by the time we get to finals, it's going to look lovely. I am an enthusiast. If a show has one point where all the horns face forward and like blow your face off, I am going to be excited. If we have a point where drums are doing amazing things, I am going to be excited. If we get to see a moment where all the music comes up and all of the color guard is just in unison and then all the flags go up, I am going to be excited. I am an enthusiast. There are some shows I like better than others, but that's because it's my vibe. I am really, really excited about this Cavalier show. I think it's a lot of fun. I think that it is just great music. I love the story behind the show. And I am completely biased in this because I have a lot more backstory. I can't wait to learn more about the other shows that are being put on the field. I can't wait to see them. Crown sounded amazing when we did the kickoff in Muncie that got rained out and ended up being a standing show. They sounded so good. But there is something different between hearing the show, which all the bands, all of them sound good. I have not listened to a DCI core and been like, that doesn't sound good. But seeing it with all of the effects and all of the pageantry of the marching arts really is the thing that I love. I'm just like, yay! So I love the Lost Boys show. I love the aspects of time. I love how fun it is. Some of the shows have gotten really heavy and serious and weighty. And it's a heavy topic, like time comes for all of us, but also there is a cheekiness to it and the way that the core interacts that I love, that I just love. So I am an enthusiast. I am enthusiastic. I love it. I love the vibe. I love the music. I love that Cavaliers always have nods to their past performances. I love seeing my kid on top of a prop, like in full character, like being his own badass self. I love all of it. I will continue to share photos of T on Instagram and over in the Law Nerd Lounge. All of them are shirtless this year. He takes his jacket off during the show and is very mindful of his tan. So you are going to see all of my kids' muscles all summer because he's shirtless at every rehearsal. And so you are going to see lots of teenage muscles. There are lots of muscles. He has muscles I didn't know that he has. To all of the Law Nerds that I saw during our travels, it was lovely to see all of you. You guys always fill my heart up. I love seeing you IRL. Thank you for coming up and saying hello. We will talk about Dave at another time. We got to go to Dave. It was Griffin's first Dave show. There was an entire not sober like bachelor party behind us, which is not Griffin's favorite. So that was an adventure. We'll talk about it. Griffin was just like, really? They are so drunk. Griffin has not often been around super inebriated folks like in their late 20s, early 30s. So for Griffin, he was just like, ugh, which is hilarious. But we daved. It was lovely. And we will talk more about Griffin going to Dave, but Griffin was just like, ugh. DCI was wonderful. Dr. B hurting his back was challenging. Driving from Michigan to Tennessee with the back injury was a delight. And it's good to be back with y'all and to do something that feels a little more normal, like go to court in South Carolina. That feels more normal. It feels like we're just like slipping back into 2022, 2023 with Murdaugh again. So I will keep you guys posted on all the other things. There are other cases I will keep you posted on in the app. After Dr. B has doctor's appointments later today, I will keep you in the loop. And we're going to go to court. Let's talk about Murdaugh. Hustle, I was in Michigan for 17 seconds. I was in Michigan for the briefest of time to go to the community show in Adrian, Michigan, and then was back from Michigan. We had been in Indianapolis. So Tennessee, Indiana, through Ohio, Michigan, back through Ohio, back through Kentucky, back to Tennessee. It was a long ride. Adrian, Michigan was lovely. The drive up is lovely from Indy. So, sweet and salty, does Dr. B require surgery? We don't know yet. We are waiting for imaging. We need more imaging. I'm optimistic that maybe not. So I am up for more imaging. Darla, I'm going to post the answer. I'll probably save this for Q&A. I'm going to post the answer because between when I posted that and finished Dave, I was going to post it, and then Dr. B got hurt, and then everything kind of went sideways. So I didn't get to post it, but I will post it. We had a few of you get it absolutely correct. And so we will. Okay. For those of you who are like, my kid went to Adrian College. It's beautiful. It's beautiful. Truly. And Adrian College has been a wonderful host to the Cavaliers for years and years, but they enjoy the Frosty Boy and getting to, go to Country Market and all the rest of it. They really enjoy training in Adrian. Plus, it's light forever in Michigan. Like, it's light forever. It's like, what time is it? I don't even know what time it is. It's light forever in Michigan. And then it was cooler. I mean, until this week, because Jesus, but it was cooler for a lot of their training camp than it has been. So they've gotten to enjoy some of that weather. And now the weather is like death to all of you. Heat, all of the heat. Enjoy the heat. It is Miserable. It's like summer decided it was going to happen all at once. And it's today. It's today. It is definitely hot. It is definitely hot. But let's go to South Carolina, shall we? Let's talk. We haven't flown yet. Let's talk about Murdaugh. Murdaugh's murder conviction got overturned. What happens then? We start back at the beginning. Murdaugh was indicted, so we start back after the indictment. We have not covered a case like this that's been overturned on appeal where we are getting ready for a new trial. We have seen retrials. We have covered retrials. But this is a retrial with a brand new judge. I do not know if they are going to be trying it in Colleton County. I imagine they're going to do a change of venue. I think they have a pretty good argument. We might see venue changed. Court today is not going to be in Colleton County. It's where the judge normally sits. So they all kind of went to her versus going out to Walterboro. And we are going to see a lot of similar players, but some new ones as well. And I'm interested to see what happens. I'm interested to see what the defense's arguments are. They had filed a bunch of motions that we haven't gone over yet. Excuse me. And some of the common questions I get about a retrial: do they have to put on all the exact same witnesses? No. Do they have to go through all the same evidence? No. But the defense has everything. The prosecution doesn't have to follow the same strategy at all. And in this case, they're going to have to limit some of the financial crimes information. We know that that's going to be limited down just based on the kind of caution in dicta that the Supreme Court gave. But also now that Murdaugh has pled to all of those, we're going to see a narrowing down of the financial crimes. It's still going to come in because it is still that gathering storm that we saw Creighton Waters talking about. They're going to want to explain, even though they don't have to prove motive. They're going to want to explain because most jurors are going to sit there and be like, I don't understand how everything is fine and Murdaugh's riding around his property with his son looking at the trees and then all of a sudden he's murdering them. We need to understand more. Though motive does not have to be proven in Alex Murdaugh's case, jurors want to understand why. So some of the financial will come in for the background of what was going on, because that has to be, I think, explained at least somewhat. And it's not, it doesn't have to be done the same way. And we are not necessarily going to see Alex Murdaugh testify again. I mean, they've had the benefit, the defense has had the benefit of looking at how everyone reacted to Alex Murdaugh's testimony, not just the jurors. And jurors have given interviews and jurors have talked to the defense. I think Murdaugh really did a lot of damage to himself in testifying. And yes, that is his own decision. But I think that he has a lot of evidence now that people just simply didn't believe him. And his testimony was just not credible. So he has a lot of information and they can go back and watch. They can show him. I mean, it is such a rare circumstance to be able to show a defendant and say, please try to step back from yourself and look at this through someone else's lens and see what they were seeing. And then see what the commentary was around it, see what the conversation online was around it, and be able to tell Murdaugh, I know you believe you, people don't believe you. So his decision to testify, I think, will be much different this time. And here's the thing. If they don't bring in as much of the financial crimes, Murdaugh might not feel that he has to explain the financial crimes and ask forgiveness for the financial crimes and say, you know, I did that, but I didn't do this. And if less of the financial crimes come in and the fact that he's already pled guilty to those comes in, he doesn't really have to explain himself. So I think we could see a very, very, very different decision from Murdaugh when it comes to whether or not he'll testify in this trial. I think it's unlikely that he will, but we're so far away from the thing that might change. But I think if you're standing here today on day one, Murdaugh doesn't testify. And then we'll see if something happens during the trial that changes that. But then again, I can't discount what all of you are surely saying in chat, like Jelly Bean G. But the murdacity, I know. Jory, this is a great question. Can they use his testimony? Not if he doesn't testify. So if he testifies, they can use his testimony to impeach him. If he chooses not to testify, they cannot use his old testimony to put that in as the prosecutors in this trial. So no, they can't. All right. Are we ready? This is a good point. Say something in the chat says, I still feel like the kennel video needs to be explained. Well, maybe not. The kennel video is a big deal. It's a big deal. So we'll see. Do you think it's going to be a long trial? I don't think it'll be as long as last time. I think it'll be narrowed down. Are we ready to go to South Carolina? All right. And because inevitably, chat, someone will pop into chat 15 minutes from now and be like, wasn't this from June 20? Yes, it was from June 29th. Emily was in the car for like 10 hours. Yes, it was from June 29th. We're going over it today. Thank you for just reminding them when they come into the chat that this is the first time we've gone over it from live court. So we're going to do that. This is their first pretrial conference or status conference, as you would call it. And we're going to fly to South Carolina. Law nerds, are you ready? Are you ready?
Bring the jury.
That's staying on the soundboard forever. Judge Newman's on the soundboard.
Bring the jury.
I'm ready. Let's fly to South Carolina. I know, I drove 10 hours and all I want is Wingstop. Honestly, by the time I was done, all I wanted to do was stop at Buc-ee's in Smith's Grove, go to the restroom, grab a sandwich, and finish the rest of the drive home. But by the time we get to the Buc-ee's in Smith's Grove, I am just like, we're almost home, everybody. Good work, everybody. Good job, everyone. We're almost home. Let's go. So today, let's go to court in South Carolina. All right. Your Honor, hello. This is our new judge. And I'm interested to see what the day will bring. Did I move I might have. Emily, do we need to rearrange things? Well, let's see. Just a little bit, because I had embiggened. What were we doing that I embiggened? I don't even remember what I had done. I had done something. We're gonna move court around just a little bit. Wiggle it just a little bit. This is Emily fusses with technology today. I don't think this is as much of a fight. This is an EDB fuss with technology. But there we go. Looks good to me. Hopefully it looks good to you. All right. New judge, who dis?
Give it right back to me. All right, we're here for a status conference.
Hi, Your Honor.
I'm going to get the clerk to call the case, please.
All right, let's call the case.
State of South Carolina versus Richard Alexander Murdaugh. Indictment number 2022 GS 15. 2022
is the year he was charged. Remember, there is quite a bit of indictments because each charge gets its own indictment number. So when you hear all these indictments, each indictment is each charge is a new indictment number. Not all jurisdictions do that, but this jurisdiction does. I don't know why. But it is what it is. So that's why there's so many.
00592 through 595.
Thank you. All right, Mr. Waters, how are you?
Good morning, Your Honor. Good to see you.
Good to see you. Now, let me ask you, I know some of your counsel at the table, but I don't know all of them. Can you please just let me know who the state's team is?
Who is everybody?
I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka, who is
I
here.
know.
We have John Metters as well.
I know Mr. Matters.
And see, Your Honor. You may see at various times we have.
I was wondering if Mr. Metters would be back. Remember, Mr. Metters was brought in as a special prosecutor onto this team. And by the time we got to the end of the Murdaugh trial, Metters had just like transformed into the prosecutor from My Cousin Vinny. And he was just like banging on the bar in front of the jury and preaching like a fire and brimstone preacher. He was wandering up to the witnesses, standing next to them, kind of looking over their shoulder and be like, now, can you show me where? Can you show me this? Metters was a trip, man. Metters was an absolute trip. At one point, he did say identical. Identical. Like, he was a trip. I was delighted. I'm delighted. I'm so glad that he's back. It was much. But yes, you'll notice that this is a bigger courtroom, and it doesn't look like there's any pictures or paintings or portraits of Alex Murdaugh's kin on the walls. So that's helpful. That's fantastic.
Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
It's a lot of lawyers.
Right. Welcome. Let me, Mr. Harpootlian, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
Please report, Your Honor. This is Jim Griffin.
Mr. Griffin?
Bill Barber.
Mr. Barber, good to have you.
I can't hear him either.
All right.
Poot, I know you and Jim don't care at all what EDB ex-law nerds have to say. But I'm just saying, y'all need to use Attorney Barber more. Y'all need to use Attorney Barber a lot more. A lot more. A lot more of Barber. A lot more. Also, I read this as snort. I don't know why it says sort on the deputy's vest. I read it as snort. It's going to be forever that.
I've made some notes on a status conference, and I'll let y'all talk in just a little bit.
Sit back down,
But I
Creighton.
want to go over what I want to go over. Because I want to make sure.
All of you are saying you read it as snort too. Good. Okay, good. I love that the judge is just like, I've read what you had to say, but I want to go over what I want to go over first. Fantastic, Your Honor. I want to go over what you want to go over too. I like it. Gentlemen, please be seated. I have questions. All right, Your Honor. I like the vibe. I like the vibe.
Sure that all the discovery in this case is complete. And I made some notes, and let me tell y'all, I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they...
I appreciate that the judge is like, let's back up and lay a foundation and make sure that we're in good standing, and don't assume that I know anything about the first trial. Just start with the assumption that I don't. I appreciate the laying of the groundwork.
complete text messages, cell phone extractions, and if there's any supplemental extractions, video recordings,
Y'all still
whether there's
extracting stuff?
ballistic firearms, are we complete in that?
Well, Your Honor, there are firearms. Just do not give them to Poot. Don't give any firearms to Poot. No firearms for Poot. No Putin with the firearms. Poot can't Poot around this courtroom with the firearms. It's too much. No firearms for Poots. But yes, Your Honor, there is logistics.
Fingerprints, toxicology. I think there was a blood splatter expert last time.
Mm-hmm.
I just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, him formerly being an attorney and that sort of thing. So it's my understanding, complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review cell phone extractions as it relates to his phone and that sort of thing. As always,
Every time they stand up, they are too far away from the microphones. It sounds like they didn't do any new investigation, though I imagine they will do some new investigation with regard to the cell phones. If they haven't done it yet, it's not been that long since this got overturned, and I imagine the AG's office is not, while they're fighting it, is not going to spend the money to do any further investigation on the case if they don't know what's going to happen. But now that they know, they will probably do a little bit more cell phone. And then there is going to be more follow-up on the car extraction, because that didn't even come until mid-trial last time. And I imagine there's more that everybody wants to do. So I think we're going to see some evidence we didn't see before, or more thoroughly parsed than we saw before.
You're constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive productions that were made, not only from just the murder investigations, but also from the very extensive state jury investigations as well. So we have provided those, and obviously I'm not aware of anything in the categories that you mentioned that have not been provided to me.
And not anything that needs to be reanalyzed or anything that the court would be waiting on.
That phone, you need to read the phone throwing. You need to read the phone throwing. And if you need to analyze the car, you need to do that. Those two things need to be done.
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night to the defense motions that were filed late last week. Came in the office Sunday to write those. One of those is their request for independent testing on DNA. As we put it in our motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're proposed to do.
With whose money? How is the defense paying for independent DNA testing? Okay.
Happy to facilitate those conversations and discuss those with the defense, and then with your honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable, and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those to the court.
Okay. All right, Mr. Harpootlian or Mr. Griffin?
We have not gone over the defense motions yet. We will get to them another day with the defense discovery motions. They're gonna play out over time, and there is too much moving too quickly. We'll get to it. The defense wants more stuff. Shock. We'll get there later. So yes, there are defense motions. No, we haven't gotten to them. Just put an asterisk on it and we'll get there. We'll get there.
Your Honor, I want to address everything but the DNA issue. I'll let you position talk.
Right, I'll talk about the DNA later.
The judge is like, stay focused.
We don't know what we don't know. And I'll give you an example. Let me hand.
Are you Aaron Burr, sir? If we get back to the trial of Aaron Burr, which for those of you that did not watch his argument to the Supreme Court, everything does lead back to Hamilton. And yes, he did bring up the trial of Aaron Burr. If we get back to the trial of Aaron Burr today, I'm going to fall over. I'm going to just fall over. But he's just like, well, Your Honor, let me just. I don't think we got to the Magna Carta, though, so there's that.
It's up to Your Honor to hand copies to.
Why are we filing new things while we're in court? There's a procedure for this. The procedure for this is not now. Not right now. Oh, it's just so
Your Honor,
dramatic.
This is a transcript of an interview done with a guy named Chapman and another officer who were.
an interview with a guy named Chapman. I'm sorry, I need to back up. I was distracted by the court reporter's glorious waves. Like the wavy, I was distracted by her hair. It was so good. Okay, Poot. The waves are so good.
Your Honor, this is a transcript of an interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, processed the scene, and were very involved in the forensics of processing the scene. And if you go to page 6, Chapman, who's in charge of the scene, says this.
All of you chat are so quick with, he's got a fast car. Yes, all of you were super quick. Emily, didn't the judge say this was a status and that the judge wants to know where they are with discovery? Yes. So Emily, what is Poot doing? Well, he's pooting. He's not telling the court where he is with discovery, but he's going to go through whatever he's going to go through to hopefully get back to the point of what he wants for discovery, because he's supposed to be answering about what discovery is outstanding. And he's talking about an interview with somebody who processed the scene, which I imagine will circle back to discovery, I hope.
This is a television interview on March 13th, 10 days after the verdict in this case.
We're back up. The interview from March 13th. Who did an interview on March 13th?
Says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to a question,
You said
I believe
he
he
says.
had some help in the aftermath. Or Rutland, yes. Captain Chapman, you know, the disposal of weapons, the moving around of vehicles. We heard so much about the SLED and AG's office, and they don't have anything. It's all circumstantial. So
And why is Murdaugh grinning over this interview?
I pose this question to you. It was a clean crime scene, staged crime scene, clean crime scene. Would you expect to find more evidence or less? And that's what's kind of hard to get people to understand, is we didn't find a lot. But why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other...
This sounds like conjecture. Okay. So Poot's reading from an interview that took place 10 days after the verdict came in of someone's speculation that the crime scene was cleaned up. Okay. And if they had evidence of that, I think we would have seen it at trial. But speculation isn't what somebody can testify to. In fact, if someone had started testifying to their own hypothesis, you would have objected and asked for a mistrial.
crime scene. Would you expect to find more evidence or less? And that's what's kind of hard to get people to understand, is we didn't find a lot. But why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other...
I have evidence. I have evidence that evidence was removed from the scene. There weren't any guns found. No guns. Evidence was clearly removed from the scene because no guns were recovered and both victims were shot. Obviously. You can't extrapolate it to more. Maggie's phone was down the road. Obviously, evidence was removed from the crime scene. Okay. But I don't think it was removed from the crime scene by law enforcement, which I think is what he's trying to imply.
Other people at the scene, he had assistance under their theory, or there were other people there. We need to have that furnished to us. And we have other witnesses that testified at trial are saying something totally different, indicating there's evidence to believe that somebody else was at the scene, or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene, along with Rutland, who processed it that night. We need, and we're in the process of doing this, to determine if they took those statements or the reports. So we don't know what we don't know. We don't know what we don't have.
Okay. He is saying that the speculation of did Murdaugh have help or not, well, we need to know. Okay, well, you've got the speculation, but he wants to know if there are additional reports, interviews, etc. If they had someone that helped Murdaugh clean the crime scene, I would think we would see it because it would make more sense in the timeline. But okay.
We need some period of time to try to process that. And Your Honor, I say this, and no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate anything. We don't have subpoenas, we don't have grand jury, we don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate it? Did they investigate it? And I must tell you, there are a lot of pieces of information out there that, and maybe.
I do not doubt there are a lot of pieces of information out there. I am also curious with this if SLED followed up on those or determined that they were rumor. Because a lot of the leads that they're going to get are going to be rumor and speculation. And there's only so far down the road you can get with rumor and speculation if you're the prosecution. If you're the defense, you can get a lot further down the road with rumor and speculation. Because rumor and speculation, you can start pointing to other things to point to doubt. But for the prosecution, they have to bring evidence that they have. They cannot bring the rumors, the nastiness. That's not what they can base their case on. So, if they followed up and determined that all of that was, I heard this, I think this, there's not much you can do with that.
They just stopped once they got the conviction, didn't do anything else, that it's inconsistent with our desire to get a conviction, or have the conviction held. So they didn't follow it up. Maybe it does need to be followed up, but we're going to have to go back and look at all of that. We're going to have to determine whether or not additional material developed since the trial. And of course, all of us were shocked by the court report's conduct in the trial. I know.
Poot, in your career, honestly, just between old trial dogs here. I'm sure that Poot has done many more trials than I have, but just between us old trial dogs here, Poot, you and me, have you ever been more thrilled? Honestly, have you ever been more thrilled than to find out the full extent of the courthouse Becky fuckery? Because I imagine that the prosecutor wanted to vomit into a trash can while sitting on a toilet. I imagine that's how the prosecutor felt. But were you giddy? Because I imagine you were giddy. Because nothing. It is so wild. And I love that he's standing there being like, we are all shocked at what the the clerk of court did. We are all shocked and horrified at what Courthouse Becky did. Y'all get a second bite at the apple. It's rare. It's so rare. But get after it. But I love that he's just, oh, whoa. Oh, whoa. You know, maybe this trial I will come to appreciate the theatrics of Poot. There are times I find it exhausting, but there are times that it's just like, the theatrics. The theatrics. Oh no, not the clerk. The horror. He's clutching pearls that he's not even wearing.
The state was. But it's hard for us to go back and look at, and we haven't done a thorough check of it, all the testimony, and read it all, not in the sense of an appeal, which we've done, but in the sense of, I mean, in criminal cases, we don't have depositions.
No shit.
Or we don't have them here.
Thank
We
you.
have a transcript of but not every, I'm sure they're going to get rid of some of these witnesses that are horrible first time around and get additional witnesses. But most of the witnesses, we have their transcript, their deposition. We need to go back and read all of that. So we need to get a sense of.
The court asked if they had all the discovery. We are still in the answer of, do you have all the discovery? And Poot is just weaving a tale of woe that they've got to go back and read it all again. That they got to go look at everything again. They got to start turning over stones.
How you cross it, just like you would in a civil case. So I can't say that we've got it all. I can't say that we don't have it all. Again, I don't know what I don't know. But
Now you know.
I think we will be very diligent.
And if you don't know, now you know. There we go. Do you have all the discovery? Your Honor, when I was a young lad, I remember the days. This is fair, chat. All of you are like, Emily, remember, Poot's a politician. He is. He's filibustering. He is. Which is probably why he references back to like revolutionary times in the US. He's like 250 years ago, back when lawyers and politicians were all kind of the same thing. He's just carrying on that tradition of a bygone time. He's just like, you know, what have we come to? All right, Poot. Let's go. I know it was really hard for me not to say when I was a young warthog. I know, but I'm not making fun of you, Poot. I'm not. So we were trying to sidestep that just a little bit.
One of the other things we talked about is Alex Murdaugh's access to that information in a way that makes it convenient for him and doesn't inconvenience anybody else. We'll talk about that. That's another motion. We'll talk about that.
I'll get to your motions in just a little bit. What I really want to know is about phone records.
The judge is trying to rein it in. She's like, thank you, sir. I'll get to your motions. Can we get back to my question? It's a fair question, though. What about Alex Murdaugh's access in prison to his records? Because one of the best resources that they have, and I don't know much about the legal mind of Alex Murdaugh, but Alex Murdaugh's got time on his hands. If Alex Murdaugh has access to all of the records, he can start going back through all of the discovery and giving information to his lawyers on what he wants them to follow up on. So they do have a client that can help them going through all of the discovery if he has access to all of the discovery, which is difficult in custody.
Text messages, cell phones, video recordings, toxicology, fingerprints. You have all that discovery.
I mean, Murdaugh's not a lawyer anymore,
We're
but
not sure.
he can still read
But
the documents.
we need to review it as if we were getting ready as brand new. I can't just really look at it 5 years.
Your Honor, I'm not sure. Sir, there's nothing new. If you had it at the first trial, it's there, because we just heard Creighton Waters say we have nothing new. Cons the Dog asked, EDB, does Nashville have a lot of mosquitoes? It depends on where you are. However, I have been veritably eaten alive from Indiana because we made the mistake of not doing a thorough bug spray before going for a river walk. That was unwise. Errors were made. So I am mosquitoed, but it depends on whereabouts you are. Away from water, not too much. So it just depends. Okay.
Doesn't mean we know we have. We'll be diligent in doing that, but certainly I would think it'll take us some period of time to review that.
Yeah, remember, I'll start out in during the trial.
Right. One other point, reminding me, we
Who can you just let Griffin talk? He's way easier to hear.
did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the Attorney General's call. That is
But you have it now.
GMC's fault for not furnishing it. We had to do that on the run. We want to go back and analyze that, have an expert analyze that even more. I do want to emphasize the Attorney General got it at the same time we got it. No inference of anything improperly.
Okay.
So that's part of what we need to do. We need to hire additional experts based on.
She didn't ask how much work you had, buddy. She doesn't need your to-do list. She asked if you had all of the discovery, and your answer is still a filibuster.
Some of the views we now have on some of the witnesses, both the state and the defense have, and they need to examine those reports to determine whether we have it. So it's going to take a little bit of time, Judge.
He really is filibustering in the true meaning of the word, because he's just filibustering for more time. Joe Jersey said we got greenheads out in the thousands today in New Jersey. Nothing quite bites like a greenhead. Those fucking things. Vicious. All right. Continuing on. EDB's thoughts on bugs. I know. Back to the filibuster.
I can't tell you today we have everything because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Yes, ma'am. So, Your Honor, we actually, SLED had sent 2 search warrants to GM well in advance of the trial, and we're told, we ain't got none. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry data, which of course was all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to a usual form. They assisted and agreed to go forward because each had our theories about what had happened next. So that was nothing with the fault of the state, and we immediately engaged in.
I agree with Creighton Waters that was not the fault of the state. The person who came in and testified, I think, mentioned that they might have been watching the trial, but all of a sudden it came up in the middle of trial that they're like, oh, we were actually able to get the data. And we were all like, what?
What we needed to do to ensure the defense had access to all that information. As to him saying, we don't know what we don't know, well, I know my obligations are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, we're always constantly auditing that and doing our obligations, but I take discovery obligations very, very seriously, and Mr. Hartford knows that. As far as these musings, I haven't watched this TV interview, and the musings of some captain about, whether the scene was clean. Well, there was evidence presented at trial that there was standing water on the concrete pad of the kennels, that the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of those kennels. So he may have been talking about that, but ultimately, while Colleton responded initially, the scene actually was in charge of and processed by SLED, and they've had access to all that information. So to sit here and imply, we don't know what we don't know, well, I'll recognize that, but I know that my obligation.
He's not implying. He's already poot scooting for more time. Well, Your Honor, it's gonna take us this way. The prosecution said we want to start this trial as fast as we can, and we want to start this trial as fast as we can. Delay benefits the defense always, and so Poot is like, well, there is so much we have to do, Your Honor. We can't do this quickly. We have so much we need to review, and the court's like, seriously. And Creighton's like, no, we know he has it. We gave it to him.
Is to provide that information to the defense. And if I'm aware of it, then it's been provided. And we have done that. They've had it since well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts and was immediately disclosed to them. They had every opportunity to process that information, and then they agreed, you know what, let's continue on. So that's not anything, any sort of indication of a bad process or practice on both sides.
So the bottom line is they have everything that you have.
To my knowledge, yes, ma'am.
Ding, ding.
And we were very careful about going through all that discovery.
And you don't know of anything else that needs to be analyzed at this time.
Well, again, we have that DNA.
The DNA, and I'm going to get to DNA in just a moment.
The defense made a motion about
ahead
that.
of time. Now, what we're talking about is some additional capability, and as I expressed in our motion, and Mr. Griffin has responded, I'm happy to facilitate discussions, and if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Now, of course, as we put in our motion, ultimately there's absolutely no evidence that Maggie Murdaugh was in a struggle with anyone, that she had any sort of defensive wounds, that she was scratched any sort of attacker. And we also know that it's very common with how sensitive touch DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring, but that doesn't mean that we are not willing to discuss with the defense anything that they want to do, and if reasonable, we'll be the first.
I appreciate how Creighton kind of meets the arguments head on. It's a very straightforward, and I appreciate his style is very straightforward. Hey, Your Honor, the defense is asking for more DNA testing. We heard about this in the first trial, that there was unknown male DNA under Maggie's fingernails. That seems to be what they are talking about, because he said there's no evidence that there was any kind of a struggle, any kind of defensive wounds. We also know that Maggie had recently gotten her nails done. We talked about this during the first trial a bit, because it did come up in trial that existed. And so the defense is asking for more analysis on that. I don't know how much more, unless you rerun the profiles, because unknown is still unknown. I don't know what more they want to do with that. Unknown is still unknown, unless they want to try to rerun that and see if in the years that have passed there's a new hit on it. But I guess we'll see. But that's what they're talking about now with regard to DNA.
Yeah, and if that needs to come back to this court, we'll do that as well.
Okay, thank you. Sure.
We know from testimony in the first trial that the chief SLED officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No longer SLED, but it raises questions with us, not whether this.
And you guys went over this during the first trial. This came up. This continues to come up.
Withheld by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the subsequent case after the trial, where he had evidence? And I think we've got to go through it and look and say, are there gaps here? Are we missing something? And for us, and look, we want to try this case as quickly as possible. No question about it.
No,
but
you
what we don't want to do is not be prepared based on what we now know happened at the first trial, And we'll have a motion probably next week that'll expand on that a little bit. We didn't feel that we wanted such a motion as that.
Well, and I don't. I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pretrial.
I enjoy the vibes. I mean, I can preview this motion. No, I don't want to do that. We're here on a status conference. I want to know what the status is. Do you have all the discovery? Well, we don't know what we don't know. Okay, sir, that's fair. All things. We don't know what we don't know. However, do you have all the discovery? Okay, Creighton, they have everything we have. Great. Sir, file the motion then.
Conferences, and I want to set a trial date. That's why we're here today. And I want to
Let's
go
Your
over
Honor.
some of these motions. I think some of them are not substantive, that I could go ahead and rule on those today and be done. And I will
like this
set
judge so
up
far.
a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. I don't know that one pretrial is going to do it for this case. We'll
No, sure
probably
not,
have
ma'am.
several.
Yes, you will.
And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpootlian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay? All right, so let me move on to my next notes.
Sit down.
And we've kind of touched on it a little bit, experts. Do you know how long, and the reason I'm just asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody
I'm not surprised. However, that's not your fault, Your Honor. It is a retrial. So yes, it's the oldest on your docket because it's a 2022 case. I'm not surprised by that. Judges do get caught up in stats though. They do. But it's not an aging case. It's not like it's not been tried. It's just returned on appeal.
who knows me knows that I will move an old case. And I intend to do that with this one.
I mean, it's not
So,
been lingering.
I'm asking,
It lingered at the Supreme Court, but it's not been lingering on your docket. But I also appreciate that she's like, nope.
Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts will be with SLED. And so I think that, we are ready, within reason, of course, to move this as expeditiously as possible. We do have another expert who testified from the FBI and things like that, but much of that is the Senate. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this, before the end of the year, late towards the end of the year. We're ready to go put together about that. And so I'm not aware on the state side of any expert issues that would provide for additional delay to include that package.
All right, Mr. Harpootlian, how about for the defense?
Your Honor, we have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need, the DNA.
Did he just say all of them are new? 8 expert witnesses and all of them are new? I'm gonna rewind that real quick. Shiki in the chat asked, what does she move by move an old case forward? She means that they're not gonna linger on her docket. She is not gonna let them have a continuance after a continuance after a continuance. She is get your discovery, get it going. She is going to keep them on track so that cases do not get beyond the ripeness to go to trial. So she means she is keeping her courtroom orderly and cases are moving through in due course. We have seen cases languish in different courts. And we have seen judges say, fine, we'll have another hearing, and then we'll have another hearing, and then we'll have another hearing. And it just keeps getting kicked down the road. She is reminding the lawyers she is disinclined to just keep things rolling, especially on a retrial, because there shouldn't be that much that's new. It's a retrial. It should be pared down. They've already done this trial once. So there shouldn't be anything that's surprising. I think he said 8 brand new witnesses for the defense, or 8 brand new experts for the defense.
When we are told it may take up to 6 months.
We're told it may take up to 6 months.
John, we have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA is, when we are told, it may take up to 6 months. It is, unlike what's been represented by the state, critical. And Griffin will address the specifics of that in just a moment. But to try this case this year, you know, these guys are talking about going to the death penalty 4 months ago or 3 months ago. To try it before the end of the year cannot be done for us to be adequately prepared.
She asked how many experts you had, and he's already filibustering about needing more time. Notice how he just went, well, these are the experts we have. This is how much time it's going to take. And then he went, shoo, shoo. And now it's going to, we're not going to get it done before the end of the year. We're going to need more time already, right into it.
And we talked about the laptop. Without the laptop, we can't try it next year. If we have to go down there and take them to the banker's box at a time to review documents. Almost
outrageous. Did you hear what he said next? It's a little hard to hear him. And Your Honor, we talked about the laptop, which is for Murdaugh to have in prison. We talked about the laptop. And if we don't have that, we're not even going to be ready next year. Your Honor, sorry. Poot, are you trying to pressure Her Honor? Are you trying to pressure the court? Well, Your Honor, if we don't get a laptop in prison for Murdaugh, we're going to have to take bankers' boxes of documents down to him, and we won't even be ready in 2027. We're going to need to start talking 2028. So, Your Honor, it's up to you. If we don't get that laptop, listen to what he says. Listen to what he says. I'm just saying.
going to the death penalty 4 months ago or 3 months ago. To try it before the end of the year cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't try it next year. If we have to go down there and take them to the banker's box at a time to review documents. Almost 20,000 pages of documents. So we came up with a way.
That's it? 20,000 pages of documents, that's it? That's it? Poot! You haven't even met some of the cases we've been covering. 20,000 pages is it? I have book series on my shelves longer than that. What are we talking about?
Well, surely, Mr. Harpillion, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge.
Good job, Your Honor.
I can't remember a case I tried 3 months ago in the material.
That's a you problem. This sounds... Oh, I get to say Griffin. Book Dragon, I was actually thinking exactly of Throne of Glass. That's exactly the series I was thinking up. I was like, because it's right up there. As Griffin would say, to quote Griffin, this is one of his favorite sayings, sometimes used to much sass, sometimes used to much great effect. This sounds like a skill issue. Your Honor, I can't remember a case I tried 3 months ago. Well, Poot, that's a skill issue. I remember too much about your case with Alex Murdaugh. That's a neurospicy issue.
Almost 20,000 pages of documents. So we came up with a way to...
Well, surely, Mr. Harpillion, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the material was on. It's
Skill issue.
ridiculous to require him, not with all due respect, to require him to have a memory of each document that he looked at almost 5 years ago.
Didn't he go to trial in 2023? Poot, you're politician mathing. This isn't even lawyer mathing. This is politician mathing. This went to trial in 2023. He didn't review these 5 years ago. He reviewed these 3 years ago. Stop playing with us. You can't. He's just embiggening time. He reviewed it 5 years ago. No, he didn't. If he reviewed it while he was in trial, it was 3 years ago. March 2023 is when there was a verdict. It's like just 3 years ago. 5 years ago. Stop it. 5 years ago was before the murder even happened. Oh no, the murder did happen 5 years ago, but he was charged in 2022. That's fair. 5 years just seems better than 3. He's rounding up. That's all. He's embiggening time.
And by the way, our solution to that, contrary to Mr.
He would have reviewed the trial transcript for the appeal.
Ironclad, no chance of it being distributed. We'll give him a laptop that's encrypted, that since there's no attorney-client on it, corrections can look at it, SLED can look at it, anybody can look at it, and let him look at that without us having to take hard copies of stuff down there and review it with him. Can't leave it with him under the court order. In other words, you just can't take him to discovery and leave it with the court order prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his.
Your Honor, if we don't get that laptop we're asking for, notice she doesn't want to hear this motion today, and he keeps bringing this motion up that he's filed. She doesn't want to hear this motion today, and now he's bringing up this motion. Your Honor, he reviewed it 5 years ago. He was in trial 3 years ago. He was reviewing this during trial. We saw him sitting at counsel table reviewing during trial. But Your Honor, if we have to bring boxes and boxes, it's just the sheriffs aren't going to want to do that, and the it's going to be too much trouble in the prison, and we won't even be able to do this in 2027. We're going to have to wait till 2028. It's just going to be horribly inconvenient. We have to get that laptop. Okay. I mean, he's persistent. So there's that.
But if we have that, and he could be reviewing these documents and expertly.
So, Your Honor, if you do what we want, it'll be so much easier for everybody.
I mean, let's not forget, he's a lawyer. Now, he's a disbarred lawyer, but he has probably more trial experience than many of the folks on either side of this court.
Challenge. How much trial experience does he really have? He probably has more trial experience than people on both sides of the table. I challenge that. How many trials did Alex Murdaugh do? I want to know. How many trials did he argue? Because it seems like this man was the king of a plea deal. Well, not a plea deal, a settlement agreement, because it was civil. He didn't do a single criminal trial. Challenge. How many trials did he do? I want to know.
So he understands what he's looking at much better than any client I've ever had. So I think it's important if you're going to try to expedite this for him to have, and we can talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks retained, have them look at the adequate material, look at the state's testimony the first time around. And of course, if they have a change in who they're using or taking a different approach, we need to know that as soon as possible.
No, you don't. You don't need to know if they take a different approach. You need to know if they have new evidence, but you don't need to know if they take a different approach. But you see, he keeps saying, I want this to go to trial fast, but I'm going to need this much time. And if we don't do this, it's going to take longer. And if we don't do this, it's going to take longer. He just keeps putting conditions on it. Your Honor, we'll get this to trial quickly if you do this and 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 this. Just get him YouTube. He can go watch the trial. I bet he puts you on like 2.5, 3 when he does.
I would point out that they were giving us discovery in the last case after the first week of trial, in the second week of trial. So we can't have that happen again. If they say they got it all, we can assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to take it back. I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. And what we're comfortable with is late spring, early summer next year.
Okay.
We can live with that. Given, I mean, if we have to go down there, one of us has to go down there 5 days a week, and we are incarcerated on one now, so it's 2.5 hours.
But Your Honor, we have to go to prison 5 days a week, and it's just such a long drive. It's such a long drive. Late spring, early summer 2027 is what he's saying.
Given, I mean, if we have to go down there, one of us has to go down there 5 days a week, and we are incarcerated on one now, so it's 2.5 hours from here. It's a half an hour to get in. So before you ever even see it, it's 3 hours. And then you only have 3 hours with them, and then it's a 3-hour trip back. That's why the laptop is so important.
Okay.
Well, if it takes 2.5 hours to drive there and a half an hour to get through security to get in, it shouldn't take 3 hours to get back. You would think that getting out would eliminate that half hour of going through security, and getting back should only take about 2.5 hours. But that's just thought.
Mr. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can talk more about that. But when I mentioned that, you know, they were asked, how soon do you need it? And I said, well, hopefully
Houston, we have a problem.
Spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are the...
I'll get
ask
to
for
the
money?
DNA in just a minute. And then we'll go forward on that. All right, let me talk about this computer at the Department of Corrections.
We have seen this argument happen in a number of cases. We have seen it happen in Sarah Boone's case. We have seen it happen in other cases where the argument of access to a client in custody is one of the number one things that frustrates defense attorneys in being able to meet with their client. And I'm not saying that that's not a real issue. However, I don't know why his lawyers need to meet with him 5 days a week unless the issue is that they cannot drop discovery off to him. And so they need to have somebody come up there 5 days a week to give him the documents he's reading in that 3 hours that he has to review the documents. However, I would imagine that that would be literally an intern, or they would ask his son to do that instead. I don't think that's going to be 9 hours of Jim's time or Poot's time or Barber's time. That is law clerk time. So if their issue is, well, we have to bring documents in and then take them out, that is an issue. We'll see what the judge says about a laptop. What they did in Sarah Boone's case, in each custody facility is different, but what they did in Sarah Boone's case is like, yeah, you can come into the room that we have designated for it. You can use it during these hours, and then that's it. So this is only 20,000 documents. It's not like he needs much. This would be really easy to give him even an iPad with those documents loaded on it. I don't even know if he needs a laptop to read through that many documents. And they have tablets that are regularly used in custody. So it's really not that much. So it really just depends on the custody facility, but the judge has to approve it. So.
I did receive your response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpelian?
look at it, yes.
He said yes.
I mean, basically, I just made myself some notes. You were concerned about the state grand jury material, and talked about
That's
a
a fair
protective
concern.
order
That's a fair concern.
and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case.
I think so too.
It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to?
That's a really reasonable balance. State grand juries, like federal grand juries, are always sealed and protected and are used in a very limited capacity for impeachment and are not to be distributed, disseminated, or anything like that. And it doesn't seem to be that onerous to say he can have everything except the grand jury transcripts, and the grand jury transcripts can be brought to him by attorneys. That's a very limited amount of information. Cons the Dog asked, this is going in front of a grand jury again. No, it's not. They're talking about the prior grand jury when he was indicted on these cases. And they might also argue for the grand jury. If I was a defense, I would argue for the grand jury from the financial crimes cases because some of those witnesses might overlap. So I would want any grand jury testimony from any witness that could be called in this trial. But even that, 5 grand jury proceedings, or not 5 grand jury proceedings, grand jury proceedings in 2 different cases isn't going to be that much information. So I don't think that's unreasonable to say that that's information he needs to review with his lawyers. And also, I would be surprised if the court wouldn't agree, if they had hearings in the morning, to allow Murdaugh to stay at the courthouse in the afternoon to meet with his lawyers, because they would have rooms for attorney-client communications at the courthouse. And then his lawyers don't have to drive, 7 hours uphill in the snow both ways to go visit their client. They could just do it on days he has court in the afternoon and set that up. So this doesn't seem all that difficult.
That, Mr. Harpootlian?
Well,
Creighton is
Your
still
Honor,
standing.
the issue of that is, what is the state grand jury material? I think, if we can designate what that is. It's beyond grand jury testimony, there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, underlying records and whatnot. And so, is that really sensitive grand jury material? And some of us introducing the evidence at the trial, I'm sure of that. But
It's a fair question. What counts?
No question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of the subpoenaed documents and information.
That's a fair question.
Your Honor.
That's a fair point for Jim, saying it just depends on what they consider. If it's just transcripts, fine. But if it's not just transcripts, if it's things gotten pursuant to subpoena, then where does that end? Because then everything could count as grand jury. That's fair.
The issue is dissemination. I mean, he has a right to read.
Oh, absolutely. I said that. It does not prohibit him from reading it.
Excuse me. Poot, put your finger down, stop talking over the court, and shush for a second. He said that. She said that. The judge said he can review it. It's the dissemination of it that's a problem. And he's still like, Poot.
And Your Honor, if the issue is dissemination, I mean, he has a right to read it.
Oh, absolutely. I said that. It does not prohibit him from reading it.
The issue is dissemination. I mean, we're just basically talking about the big Kindle. You can read on it. You can't send emails. It's not connected digitally or cell or Wi-Fi to anybody. It can be kept. Let me say that.
Stop it. The court already agrees with you.
The Department of Corrections has been extraordinarily professional in dealing with us, giving us access to them. I have no complaints with them whatsoever. But what we'd like that laptop with the warden and corrections have total access to it. It can be inspected by SWED to make sure it can't transmit an image, a message, can't be used in any way. There is no Wi-Fi at this particular institution, so it has to be by self-service. I mean, these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's a very...
Poot, you're missing the point. Also, if she agrees to give him some kind of e-reader, which, by the way, I love an e-ink screen. I could rave forever about how much I love it, but I won't bore you today. We'll do that another day. But the next thing that's going to happen is then he's going to come in and complain that on whatever type of reading device they give him, that he needs to be able to listen to audio and watch videos and watch audio of the interviews and see photos and things like that. Like it's...
very of what we want him to look at. And we could certainly do that separately with hard copy. We'd be happy to go down there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing reversed about that. But necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to the murder. So it was much bigger than they say. You know, I don't have the number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas, and so all this was in that ambit. And as well as Judge Newman issued a second, to my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. And so all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is
So there's more to this. The prison says no laptops, and Murdaugh lost his tablet privileges. Well, if you lose your tablet privileges, then that's a problem that Murdaugh himself created. Because this is why they want a court order so badly. They want the court to try to overdo what the prison does, but that's not how that works. The court can try to say, give him access to it, and the prison can say, no, he lost access to that privilege. Guess what, Murdaugh? When you lose your privileges, you lose your privileges. It doesn't matter that you're Murdaugh. So Creighton is saying he lost his Murdaugh. Murdaugh lost his tablet privileges for misuse of tablet. All of the chat is now saying skill issue. Yep. Skill issue. Oh, look at Murdaugh looking at Creighton. Okay, Murdaugh.
have a laptop. They are absolutely 100% opposed to that. And I have to remind you.
I'm going to rewind that more. I missed some of the face facing. Murdaugh's face is facing this at Creighton talking about this. If you're listening in the background, come on back. Come on back. Because, whoo! Murdaugh's face has thoughts.
Election protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. And so all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to, okay, is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member who proved the defense to him.
Contraband? Contraband? Lost his tablet privileges and contraband?
Is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member who proved the defense to him, found like guys. And so this is not a guy who was, and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down and made completely safe and I understand these issues very well. As a state grand jury made a point to partner with SCDC to fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue, and no matter what protections are put in place, there's always ways around those, and SCDC has experience with that. So
keep in mind, by the way, that contraband in the custody sense does not have to be anything. Hey, y'all. Sorry about that. My software crashed. That was unexpected. So, apologies. Hopefully we're back now. It looks like we should be back now. But apologies for that. That was a complete crash. So if you need to refresh, I should be back. But that was unexpected. Sorry, y'all. That was a software issue. Today decided it was going to have some turbulence. So I'm going to back up to what I was saying again. Sorry about that. It was not you glitching. That was a software issue for me. I don't know why, but that was totally a system skill issue. So, welcome back. But what we were talking about was Murdaugh wanting to have a laptop in custody, the Department of Corrections being like, no laptops, no how, and Alex Murdaugh being in a class of defendants or prisoners who are concerning because of the fraud convictions. And fraud running digitally is a very real possibility. And they were talking about Alex Murdaugh having contraband. And so I was just chiming in to say, remember, contraband doesn't mean anything nefarious. Said like we're in Massachusetts. It doesn't mean something that is necessarily illegal. Contraband in custody can be Crest White strips, as Corey Richards was trying to get snuck in. It could be a book that wasn't approved, letters that were not searched before they went to an individual. Contraband can be just about anything that hasn't been approved by custody. Like if you tried to slip somebody some Pop-Tarts that weren't approved and didn't come from commissary, those could be contraband, even if you're not slipping like a shiv into the Pop-Tarts. So it can literally be anything. And during trial, we had an issue with Alex Murdaugh being passed contraband because somebody had brought him a book that hadn't been searched or what have you. So contraband can be basically anything. Cons the Dog said, can toothpaste be contraband if it is an item from outside of the prison environment that does not go through proper channels, that the prisoner is not allowed to have, then it can be contraband. If they buy it in commissary, it's not going to be contraband. But if they trade it with other inmates and they're not supposed to have it, it could be contraband. So contraband can be anything they're not approved to have. So yes, Toothpaste can be contraband. If he got his tablet privileges taken away and he was using another inmate's tablet, that could be contraband. So it could be anything that is not approved for them to have. Hopefully that helps. All right. Let's get back to this hearing while they're talking about contraband and Alex Murdaugh getting his tablet privileges taken away, and that being a wrinkle in him being able to have access to records the way his attorneys want it to, or want him to.
The state grand jury made a point to partner with SCDC.
Oh, I Am Heather said there was literally a limit on honey buns where I was working. Oh yeah, having too many beef sticks could be contraband. So yes, contraband in the sense of custody is unapproved things. Hoarding can be contraband in custody, for sure.
Fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue, and no matter what protections are put in place, there's always ways around those, and SCDC has experience with that. So the fact remains is he's an inmate, and SCDC is adamantly opposed to there being some laptop that he has access to, and for this idea that SLED is going to be able to review attorney communications and work product on that, I don't understand how that's going to happen. Now, SCDC is happy to accommodate the defense and to any meetings they have. And no one says that the defense can't bring down digital evidence to review with them while it's under their supervision and then take it with them when they leave. That is absolutely the way it should be, that ultimately this information, whether state grand jury or not, is too sensitive to have an inmate, despite what protections are put in place, have a laptop, because frankly the reality is that inmates are constantly and successfully violating whatever protections are put in place. Despite everyone's best efforts, you're doing a great job. It's just the nature of it.
Okay. Sure.
I had a series of emails, and I don't see the Department of Corrections here today objecting. I had email chain with the warden at the particular institution, and he doesn't raise those objections. He just, and we were bringing another laptop, and we can't have cellular or Wi-Fi capabilities. So,
just because you can do it for one client doesn't mean you can do it for this client.
and that's what this says. So, and with all due respect to the Department of Corrections, if we don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barber, or Ms. Fox have to go down there, 3 hours down, sit with them for 3 hours back, we're talking about at least the end of next year, if not the beginning of the following year, to get this report. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a
Okay, this is a lot of hyperbole from Poot, for sure. But do you see the way that he's telling the court what it's going to be? But Your Honor, if we don't get what we're looking for, it's going to take us until at least 2028 to do this trial, because we have to drive down there and babysit him. Come on. You have no law clerks? Really? But Your Honor, we can't possibly be ready if we don't get what we're asking for. Trying to hold the court a little hostage, methinks.
laptop that doesn't have any capability to communicate or copy. And we'll be happy to have SLED inspect it. We'll be happy to have Department of Corrections inspect it. But
that's not the problem.
You know, the idea, we bring laptops in. We were given, as you can see, permissions to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it, or some office at the institution keep it and give it to him when he needs it? And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Warner's job to legally prejudice the defendant, but this is beyond the pale. This is beyond the pale. I'd ask you...
We've now bridged into a different topic. But Your Honor, bringing him in here chained up is just preposterous. He's chained up like a prisoner who's been convicted of dozens and dozens of federal and state crimes, who is serving more than 40 years in prison. He's just, Your Honor, it's just horrible. This is not in front of the jury. He doesn't have the right to be in street clothes at this point.
To remind Mr. Waters that he has an ethical duty to see that justice is done, not to get a conviction. Thank you.
Mr. Harper, there's acts.
I don't.
And that.
Okay, we're not going to go there.
And I have no intent to prejudice anyone. Prejudice suggests a decision on an improper basis.
And the court doesn't take it that way, Mr. Waters.
Thank you, Your Honor.
All right, let me tell both of you. I took the liberty of calling the warden and talking to him about the laptop situation. And because I too used to practice law, I remember terabytes of discovery that I had to carry.
And this doesn't seem like terabytes of discovery, truly. But I like the judge is like, back in my day, we made it work. Okay.
To my clients to go see. And I know that it can be cumbersome, and I would imagine the discovery in this case is a lot. How many pages do we have, Mr. Waters?
He said 20,000.
It's very extensive. It's half a terabyte.
Half a terabyte.
Okay. I talked to the warden. He will not allow a laptop.
That answers that question.
And for safety reasons. He said he would, quote, make available a conference room. Counsel may bring their computer. They could have a law clerk come.
Right.
Or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. And no other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpoolian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop
Unfettered
computer
access
in his cell. It's for safety reasons. That's out of my control. I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety. Okay?
Dr. Warden, we're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room as he would with us to look at it there. Does that make a difference?
Well, I'll ask him. But when I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally.
We don't have an objection.
Okay. We'll follow up on that in our next pretrial. Or if I can, I'll probably let you know before pretrial. But if he says no and it's for security reasons, then the answer is no. I'm not going to allow it. Do you understand, Mr. Harpoolian? Mr. Waters?
Law clerk or other person, paralegal?
He'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said He's not going to limit you to 3 hours.
Okay.
They can stay 8 hours if they want.
That's
He
helpful.
will make a conference room available so he could see the material. It does not have to be a lawyer. Okay, that,
Your Honor, I spoke with the director at Federal Counsel this morning, and they expressed the same thing. We're here to facilitate the defense doing that.
right. You know, I want him to have all his discovery. He's entitled to all of it. You know, it's safety concerns. It's,
Your Honor, we're 100%.
if you can have a law clerk or a paralegal go down, then you're satisfied, Mr. Harpootlian, that'll help you out?
Will dramatically, if we're not limited to 3 hours, it makes that 2.5 hour trip down and 2.5 hour back worthwhile.
Okay. Well, then I will verify that and send y'all an email tomorrow on that, if that's okay. All right, perfect.
Thank you, Your Honor.
All right. Now, let me go through.
But wait, there's more.
I had a motion filed
wait,
for the
there's
defense,
more.
and I just want to put this on the record.
All right. So where are we with the laptop issue? The warden says no laptop. So they're going to have to figure out how to get materials for Alex Murdaugh to read and to take a look at. That is a reasonable workaround, but you don't get special treatment. So that's period. The rules in prison are often different than the rules in local custody and more strict. And the court's acknowledging that. Look, there's only so much the court can do. The court can't tell the jail or the prison to do something that's outside of their policies and procedures unless it's violating a fundamental right of the defendant. We can give you more time. Just tell us the name of the person. It doesn't have to be one of the lawyers. Those are all reasonable workarounds. And it's not unusual for these to be things that defense attorneys have to do. Alex Murdaugh is not getting special treatment, but he's not getting treated unfairly because he's Alex Murdaugh. He's not being treated differently than other in custody defendants are being treated. He just feels that way because he wants to do what he wants to do.
The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpootlian where he withdrew that motion. That still stands, Mr. Harpootlian?
Well, if he withdrew the motion, why is Poot arguing it again?
Yes, Your Honor, although we may renew the motion, the reason for this is potential jurors are watching this right now. It's going to be wherever this
Well, then they're not going to be jurors on your case because they're watching too much about the case, so don't worry about it.
goes. It's going to be difficult to get a jury. And to the extent that parading him around in a jumpsuit shackled like an animal impacts their view, it's going to make it more difficult for us to get a jury. Now, again, Mr. Waters' argument is specious. He's not dangerous. The only thing he's been convicted of is stealing money. Now, Judge Newman let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is one that prejudices our ability to get a jury. So I would ask.
Speaking of specious arguments, Poot, I think it is a specious argument to say that somehow Creighton Waters is manipulating perception of Alex Murdaugh because he objects to him being in court unshackled. He has been convicted and is in custody on other crimes. And if potential jurors are watching this, then they probably shouldn't be jurors on this case. I think it's also specious to withdraw the motion and then stand up in court and try to argue it again. If you withdrew the motion, then sit down. If you didn't withdraw the motion, then don't withdraw the motion. But you withdrew the motion, so sit down. Why are we hearing about it? I mean, he's not in a spit mask and he's not, just strapped down to a gurney and wheeled into the court the way they did at times with Taylor Schabusiness in like the full spit hood and the rest of it. That's not happening. This is disingenuous to me.
Absolutely be allowed to come in the courtroom unshackled in, I will call them street clothes. Now,
So are you renewing your motion now?
sure.
Just want to make sure.
What I wanted you to see today
Then why withdraw it?
is this. I mean, chained around the waist, chained with the hands, chained on the feet. I mean, this guy's not a serial killer.
He's being treated like every other defendant. And isn't that Poot's problem? You're just like everyone else, Murdaugh. You're being treated just like everyone else. How awful for you. That must be so difficult. Truly. The tragedy. Your Honor, he's chained around the waist like everyone else.
What I wanted you to see today is this. I mean, chained around the waist, chained with
I mean, taller than Banfield. So there's that.
the hands, chained on the feet. I mean, this guy's not a serial killer. Not, Ted Bundy.
Hey, Poot. He's in court accused of murdering his wife and son. So he's a multiple murderer. Your Honor, he's not Ted Bundy. I don't think that's a helpful argument for you. Also, he stole from people who trusted him, who lost everything because they trusted him. It's not like there isn't a level of despicableness to Alex Murdaugh's character. However, to Alex Murdaugh's benefit, he looks healthier than he did in court for the first trial. I think sobriety has probably done well for him. But he's not Ted Bundy. Great argument, Poot.
Chained around the waist, chained with the hands, chained on the feet. I mean, this guy's not a serial killer. He's not, Ted Bundy.
You can sit down, Mr. Murdaugh.
The court sit down.
He's accused of killing his wife and son, but he was accused of killing his wife and son, and Judge Newman allowed him to come unshackled in his street clothes every hearing we had.
He hadn't been convicted of anything yet when he was before Judge Newman. Also, it's going to be interesting. Keep in mind, Leonard's just asterisk. Keep in mind, he's going to invoke Judge Newman when it benefits him. And then he's going to say, well, Judge Newman's orders no longer stand when it benefits him. He's going to switch that up throughout these hearings, I'm sure, as we get forward towards cases or forward towards this case going to trial. Hills and Mountain said, why did he just stand up? Because Poot told Murdaugh to stand up to show the court what a waist chain looks like. He's mansplaining to the court. Actually, that's not fair to men. He's Poot-splaining, because I think he would do this to any judge. He's Poot-splaining. And he does that. He's sorry, I saw my camera just freeze. Apologies. He's Poot-splaining. He's theatrically showing off his client. Like this is a circus, maybe not a zoo. Okay, Poot. All eyes on me in the center of a ring. Poot loves the theatrics.
All right, Mr. Waters, I did read your response, but I'll be happy to hear anything and I'll take it under advisement.
Well, again, they withdrawn the motion and now they.
Now they
This goes back to, it's not the state's fault he's an inmate serving a 27-year sentence, okay? This is, again, SCDC's policy for non-jury court to be dressed out in restraints. He's not only facing 27 years, but
27 years is only on the state cases. He has over 40, little over 40 on the federal cases.
your sentence, okay? This is, again, SCDC's policy for non-jury court, is for him to be dressed out in restraints. He's not only facing 27 years, but an additional 40 years in federal court, and then he's also indicted for a double murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals in any escape attempt is to become unrestrained and in civilian clothes. So I'm here to represent what is basic policy and procedure for inmates serving long felonious sentences with SCDC. I completely understand that when we have a jury, the calculations are different, and that is going to be a different thing to do. But the remedy for all of that ultimately is with our process. It's going to be jury selection, and it's going to be instruction from the court, which the jurors are going to follow, and which I know our citizens can.
Okay, thank you. All right, I'll take it under advisement, and I'll issue an order on that. Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pretrial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is
He said
you're
6 months.
asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now, that I've been interfacing with, and they will be better able to answer specifically how long it will take. We've agreed to pay for it, and just background information.
I'm going to let you pay for it.
And these murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on.
Oh, you want to do some IgG. Then the lab might have to make some additional SNPs to do some IgG testing. For those of you that are like, Emily, what are we talking about again? IgG is the investigative genetic genealogy that we saw and have talked about in the Koberger case, and that we have talked about with regard to the investigation into Nancy Guthrie. However, his statements about technology are not accurate. He's also not really, I'm gonna leave that be, but the IgG was around. It just wasn't used as frequently. And I don't know if IgG is going to help here, but maybe it will. So let's see.
On the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year on 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place.
Oh, so same lab. So they want to use the lab that was used in the Koberger case. Right. When I tell you that defense attorneys, prosecutors should too, I don't know if they do as much, but when I say that defense attorneys are watching what's happening in other high-profile cases, they are watching what's happening in other high-profile cases. And we saw that in the Corey Richins case. They referenced back quite a lot to the Karen Reed case, and they brought in some of the same experts from the Koberger case. We're seeing that overlap here. We've seen it in other cases. And I imagine when they go to make their motion for change of venue, they're going to bring in the same expert that we saw used in Koberger, in Richins, that's being used in the Tyler Robinson case, and will be used, I imagine, here as well. So they are watching what's happening. And so I'm interested to see where they get with the IGG. So let's listen to Griffin explain to us cases that we've already gone through.
Statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back.
Well, they have to do the SNP profiles first, and then they worked with the FBI to do that, but okay.
To a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberger. That's how they solved the Moscow murder cases, was through Othram Lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses analysis.
Are we going to start getting into the different types of SNPs that are used? Because if they didn't make those profiles, they might not be able to make those profiles now. So he's starting to talk about the CODIS runs. The way the DNA is run through CODIS and the way the DNA is processed to be run for IgG are not the same. I really wish he would sit down and let Barber explain. Because Jim is trying to explain things in like a game of telephone when I know this has got to be Barber's area that he's been working on. But all right.
Lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that.
But if they don't have enough material to make a profile to go through CODIS, do they have enough to make a SNP profile?
And so, we're going to have to see what the lab says. They've asked me to get information from SLED as to, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd asked Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around the country, and they're certified. They work with law enforcement. I don't know that they worked specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send.
Correct.
They could send.
And they can work with the extract that SLED used when they did their STR analysis.
Yeah, but I don't know if they had enough of an STR analysis to run it through CODIS. You just said they didn't have enough, and that's fine. And if they didn't have enough, then that's not fine. Insert funny name said, what is he asking for? I can't even tell. Because he hasn't asked for anything yet. He's lost in the sauce. What they are trying to get to is that they want the court to issue a court order to connect SLED's DNA lab to Othram so that Othram can run the DNA that was located on the victims. I don't know if it's multiple points of DNA or just one, but they don't want it to go through SLED again. SLED's already done this analysis. They want SLED to give that information to Othram, which if SLED was able to complete a profile, and it's unclear to me if they got a complete profile to do this, then they should just be able to transfer the data. That's not hard. They shouldn't need to transfer any material. So I'm curious, but there were times that there just wasn't enough. So if there are complete sequences, that's just data that can be sent.
They can work with that out there. They've told me, but
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities and proposals are and any procedures. And I'm then, once made privy to that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back before Your Honor. That's precisely what I put in my motion is let's talk to, let the experts talk so that my experts can hear, what it is that they propose to do. And I'm happy to do so.
and I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alex Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential, and that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be
nothing
innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get.
Those are
And
good
we will
questions, Your Honor.
discuss this at our next pretrial.
Good questions.
Anything, Mr. Waters, you're going to give them the name of the person at SLED that he can get in contact with. Let's see if there's a viable sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But
Right.
they work with a lot less than
Okay,
SLED.
well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward, and we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away. All right. Let me move on to the motion for change of venue. The defense filed a change of venue motion. The state has not had the opportunity.
Keep reading, Emily. I didn't realize they had already filed their change of venue motion. We knew they were going to file a change of venue motion. I didn't know they already had. As I said, we will get to their motions as we get to it. But if the state hasn't already responded, they're going to have to just wait until they get there. Sorry, chat. I'm trying to see chat, but some of my stuff on my end is freezing because of course it is. It's just spicy. But we will go over the change of venue motion down the road. I'm going to wait until we have all of the briefing in, and then we'll go through all of the briefing and do that together because they'll have their own day to hear that. So we'll go through it. I think change of venue, in a lot of cases, I'm fairly skeptical. Change of venue is going to be interesting here. And I'm curious to see what goes on with the DNA. I think if there's enough to test and they can test it, let's test it. I'm curious. Let's see.
To answer yet. So I'm going to give them time.
Well, yes.
In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions. If y'all can agree on it. If you can't, make your own suggestions, and then I will decide.
Oh. Well, that's interesting that the court may allow them to agree to a change of venue. That actually might be beneficial. I don't know. I'm curious to see what the state will do with that. That might be something that everyone agrees on. I really like that the court is open to saying, if y'all want to agree, just agree. But I can see in this case where a change of venue might be absolutely necessary. And I think that allowing the attorneys to decide and then give some options for different counties where it might be easier would work. Curious that she's giving them that choice. Because we saw a lot of times that the attorneys, we've seen cases where the attorneys agree on stuff and the court's still like, I know you all agree, but that's not what we can do. But interesting.
For you, if we go that route.
Poot, stop interrupting the court. That's my job. And I'm pretty okay at pausing most of the time.
Give me some suggestions, if y'all can agree on it. If you can't, make your own suggestions, and then I will decide for you, if we go that route.
Even in spite of the acrimony here today, the lawyers have been able to talk to each other, and we have already talked about this. I think we'll have continuing discussions, and depending on when you set your next pretrial.
An answer for me?
Poot was really hard to hear in that, but I think what he said was, even despite the acrimony here today, and Poot, there's been none from Creighton Waters. Creighton just gives pretty direct answers. But he said, even though there's been acrimony here today, we have been really able to talk to each other. Right. I saw a couple of you ask, what happens if there's a change of venue? This judge is the judge. So the Supreme Court, I went over the dockets a little bit ago, but the Supreme Court assigned this judge for all purposes. So this judge goes where this case goes. So it's this judge is this judge no matter where it is. So that's the judge has been assigned for all purposes.
Try, if I don't have to keep driving down the public train.
Yes, Your Honor. Of course, without taking a specific position right now, I've
Right.
Mr. Harpootlian this morning that, we can kick some things around. And like you just said, if we agree, great. If we don't, then the court will decide.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me
The court's like, let's move it along.
I see Mr. McCullough sitting out there, and then I also have another. They're both the same protective order, but they're wanting two different things.
Okay, now we all see Mr. McCullough.
Ours is not the same as Mr.
That's right, they're two different things. Right. As far as, but I think before we go there, Mr. Harpootlian, Just
Just let the court do what she's doing. The court's in charge of her courtroom. He keeps like giving suggestions. Stop micromanaging, Poot. Okay.
I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Again, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities and medical sensitivity.
Right, because I did, yeah, and I did receive something from SLED, an email from SLED.
That was General Counsel Adam Whitson, who's present here today, and SLED.
Where is he? Okay, I did receive your email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay, those were all.
I appreciate Creighton's demeanor with the court. I will say this was Poot's demeanor with Judge Newman as well. This seems to be Poot's demeanor all the time. Poot is going to be Putin. He's just, hey, Your Honor, can we do this? Hey, Your Honor, can we do that? Poot's used to being in charge, it seems. And again, in politics, you can do this differently. I also think the judges let him get away with it because he did this in his argument with the Supreme Court. This is his demeanor. We've seen him in front of multiple judges now, and this has consistently been his demeanor. She has reined him in. I'm interested to see if down the road she reins him in a bit more. But you know, he's consistent. He's consistent in his in-court demeanor with everybody. And I just, there are times that it is much. But also, if you are sitting at the defendant's table, you want an attorney that's going to do everything. And you cannot accuse this defense team of not trying it. So he's going to be trying it. It's just, there's times that are just, it's just too much. It's just too much. So she reined him in at times. We'll see how that goes as we continue going with this case. But his in-court demeanor at times is just much for me. Also, I personally struggle, as many of you are on this same struggle bus with me, I personally struggle with his roundabout way of answering. It is one of those things that gets under my skin more than most things, because she asked you a direct question, just answer the question. When he shoots off in another direction, I'm like, nah, what are you doing? Stop filibustering. Bring it back. Answer the question that you're asked. It makes it hard for me to follow. But he does love the theatrics. So here we are.
All my bullet points.
But I appreciate getting to see all of them interact and hear what the defense is lining up for things they're going to keep arguing.
Give me an answer on that, and we'll decide at the next pretrial then.
Who are you making eyebrows at in the courtroom? Are you looking at Joe McCullough? Probably.
Something from SLED, an email from SLED.
That was General Counsel Adam Whitson, who's present here today, and SLED.
Where is he?
Oh, they were looking back at the general counsel from SLED.
Email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay. Those were all my bullet points. So let me ask the lawyers. Did I miss something?
Oh, no.
Is there something you would like to add?
No, Your Honor, no. Warning. For all of you who are asking, who is Joe McCullough? He is the attorney that they panned to briefly with the glorious locks of gray hair. like silver gray hair, glorious hair, but he represents the egg lady juror. And there have been motions pending, we covered a while back, about whether or not the hearing and the chamber's conferences with the Judge Newman and Courthouse Becky and all of that about the egg lady juror will be unsealed. And so when they were talking about protective orders and unsealing, part of that might be the egg lady juror protective order, because the Supreme Court said we no longer have jurisdiction. We're not taking up the question about unsealing that information from the trial court. So at some point that might get unsealed. And I'm interested to see what happens if it does get unsealed. So we will cover it if it does. But the Supreme Court said we've transferred jurisdiction back to the trial court. This is the trial court. So that motion about unsealing the hearings with regard to the egg lady juror are going to have to come up in this court. And I wonder if that's one of the protective orders they were just talking about.
One thing Your Honor had mentioned is the location of pretrial hearings. And from the state's perspective, we're happy to come to wherever Your Honor happens to be for the trial proceedings.
Okay.
Your Honor, we're more than happy to come wherever you are, although this production of these hearings might not dictate, but certainly suggest we come to a venue like Washington County, where there's plenty of room and have an extraordinary program to accommodate everybody.
I think they've done a really good job with security and with the press and being organized. And this is my home county. Let me just ask and throw this out there.
So the courtroom that they're having the hearing in today is where the judge normally sits. And they're talking about whether the judge will travel to a different courthouse for the hearings or if they will be here in the county where the judge normally sits.
Mr. Waters, is there any objection if we hold pretrial here? The reason being we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington, which I would not want to do to any county. Sometimes I go to really small counties and I.
This judge sits in Lexington County. And I appreciate that she says that this case will not disrupt other proceedings in the courthouse because it has the capacity to handle it versus smaller counties. Judges in South Carolina do move circuit a little bit more than in some other jurisdictions. This really depends jurisdiction by jurisdiction. And when you get jurisdictions that have more rural aspects, you get judges literally riding circuit that actually go to different courthouses and hear cases. So it really just depends on the jurisdiction. So yes, they actually ride judicial circuits still in some jurisdictions.
I don't think it would be good to hold a pretrial there. Does it suit?
I mean, from the state's perspective, and again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Solicitors, office, law enforcement, the court, of course, is very accommodating here. So this is certainly, I think, would be of most convenience for parties as we get ready for the winter months.
Okay, it's not far for anybody to travel, Mr. Harpootlian? Okay, then I will try to make sure that when we arrange these pre-trials that we will try to be here in Lexington. Anything else, Mr. Waters?
I believe that's it from the state.
Defense?
Your Honor, that's all we have, but if we could talk about that schedule. For
Wait.
Oh,
That's all we have, but. That's all we have, but. Carrie Boss in the chat, or Bose in the chat, said, is the retrial going to be in Lexington? That has not been decided yet. The court has asked if they can have the pretrial hearings in Lexington County, South Carolina. Because that is where she generally sits, the courtroom's large enough to accommodate everyone. It is close for the attorneys. Everyone has said, yes, the pretrials can be there. The retrial is currently set to happen back in Carlton County where the original trial happened. The defense has filed a motion for change of venue. The court said today, if you guys agree on a change of venue, let me know and we can work on it. So the next trial may be in a different county. I don't know if that would be in Lexington or not, but we will see if it is moved. I would be surprised if it stays in Carlton County. I would be surprised. I think it being in a different county is more likely at this point. So that would be my suspicion. But the court has to decide that.
I'm getting ready for it right now. Let me tell you what I have. I've gone through my calendar. And so it's hard to get lawyers together, especially when I have this many lawyers.
Mm-hmm.
So
herding cats.
Let me throw some dates out.
Cats with complicated calendars.
August the 13th and the 14th. July 29th, the 30th, or the 31st.
Your Honor, so I think the chronological order, the first would be
July 29th.
I'm scheduled to be out of state with that, from the 29th through the 31st.
Okay. Then let me move on to August 13th and 14th.
We're talking about the next pretrial.
We have a mediation on the 13th. The 14th is available. Yes, sir.
We got the 14th. We got the 14th going once, 14th going twice.
August the 14th it is.
We got August 14th.
That will be our next pretrial. Now, with that said,
we should hear more
I'd
about
like to have.
we should hear more about the DNA then. We should hear more about the change of venue then, and I will make sure we cover those motions before we get to the next pretrial in August.
All motions by August the 7th, if I could. I like to read my motions. I like to be prepared. So if I could have
who
your
doesn't?
motions.
It would stress me out.
I understand that some of them are late. You might think of something at the last minute. That's fine. But please don't file something at 10 o'clock at night and expect me to rule on it in the morning.
That's a fair expectation.
I apologize for those coming in late. We had
No, you're fine.
I came into the office just to make sure we had something out there.
Mr. Waters, you're fine. I was not planning on ruling on those motions. Now, had I been, I might say something different. But please don't do that to me, okay? Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's you.
When Judge M had conversations about trying to pick a jury in the Corey Richins case, he was like, all right, everybody, look at your calendar. We've got ski week. We've got spring break. We've got this, this, and this. We need to try to get this trial in between all of those dates. Can we do that? And so the judge is like, I am trying to get jurors. MNELS says spring break is the least of her concerns. Spring break is a huge concern for her because she wants to pick a jury. And picking a jury when you are bumping up on when people are going to be traveling a lot becomes exceedingly more difficult. So she is thinking of juror complications and is trying to navigate complications for the jurors, not as much for the attorneys. And judges, especially when they've been doing this a minute, they know when it's harder to pick a jury. You try to pick a jury the week of Thanksgiving, it's a nightmare. So the judge is trying to be mindful of the fact that jurors will have a lot more difficulty serving on a juror while kids are out of school. it just becomes much, much more difficult.
Usually right before Easter. It is the March. Is it the 28th? I think it's the week. It's March 28th. So I'm thinking April 5th. I know that we'll have a new Attorney General coming in. Mr. Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new Attorney General time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well.
Tell all y'all.
When I set a trial date, I don't do continuances.
Period.
I don't do it. It better be a really good reason.
Okay. This court is like, when I set a trial date, y'all are going to trial on that date. I'm giving you a heads up. I don't do continuances. All right, Your Honor. I like it. I like the vibe. Heard. She's like, let me tell you what. When we pick a trial date, we're all going to talk about it together now. But when we set that trial date, we are carving it into stone. And you're going to trial. It's going to be a cold day before we change that trial date. Okay. They're all on notice. Y'all have been warned. Trial date means trial date. I like it.
When I set a trial date, I don't do continuances. I don't do it. It better be a really good reason. So, how does April the 5th sound, Mr. Waters?
Yes, ma'am, they'll be ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not. We're going forward.
more than happy with that. Mr. Murdaugh is more than happy with that. I just, again, DNA.
I'm more than happy with that, Your Honor, except. I'm perfectly happy with that. However, okay.
Everything is right, because the science in all these areas is much better than it was 5 years ago.
I understand. Technology changes overnight. Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme.
How is Griffin wearing a lapel mic? How is it that we can hear Griffin so well and can't hear Poot at all?
Court reversed this case on misconduct by clerk of court, but the Supreme Court also addressed financial crimes evidence, and depending on
Save it for your 402s, buddy.
how much of that or any of that comes in, will determine the length of the trial in many respects. Judge Newman last time would not rule pretrial on that issue, and it's going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial.
Well, that's not going to happen.
And so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during
the court's not going to curtail all of it pre-trial. And even if some of it gets curtailed pre-trial, doors can still be opened. And so you've already defended against all of it. So the
trial, or are they going to be able to put it up? And so I'm just asking maybe some earlier date where we can have, Your Honor, address those issues.
We will. I'm just going to tell you, I
motions.
like to address all pretrial matters beforehand. Because when I say April the 5th, we're picking a jury and going forward. All those issues
Yeah,
should
bring in the
be
402s.
decided by then.
Your Honor, that's my practice as well. We filed extensive pretrial motions prior to the prior trial, laying all our cards on the table. It's exactly why we thought that was admissible, and we'll do so.
Thank you. I appreciate it. Anything further before we adjourn, Mr. Waters?
Okay, so the court's like, look, I agree. We will do the pretrial motions well ahead of the trial date. We'll have those rulings ahead of the trial date. April 5th is not for us to do pretrial motions, 402 motions, your motions about experts, your motions in limine. It's not for that. April 5th is to start picking a jury. Everything else needs to be done before.
And Mr. Harpootlian?
Nothing for the defense.
All right, perfect. Have a good evening.
All right. And there we are at the end of the first pretrial hearing for Alex Murdaugh. We have a next date. We have a tentative trial date. I'm going to say tentative because we will wait and see. I don't know who Murdaugh's turning around and saying goodbye to in the courtroom. It's probably more of his legal team because that's where they're all standing. But that is the end of this hearing. So I'm going to answer a few questions, and this hearing is all we are going to get to today. I do not know if I will be streaming tomorrow, so make sure you have the Law Nerd app. We have had some tech issues today. We have had some life issues today. We have had all the issues, but we're going to summarize and we're going to get to your questions because Alex Murdaugh was back in court for his very first status conference on his murder retrial. After the Supreme Court overturned his case, that case goes back to pretrial status, and the court set a tentative trial date for April 5th, 2027. The reason I say tentative is because the court asked for more information about what the defense wants to do with DNA testing and how long that will take. And the court expects the defense to have that information for her before or at the next pretrial hearing, which, hold on one second. Let me tell you when it is, because I wrote it down, but it's on a different page. We got to zoom. On August 14th, 2026, they will be back in court. This judge is the judge assigned for all purposes. We know that the defense after this hearing has, well, that sounds awkward. We know that during this hearing, they discussed motions the defense has filed that we will be covering. They have filed a motion for change of venue. They have filed a motion because they want to do IgG DNA analysis and actually brought up in court the Koberger case and want the same lab to evaluate DNA or a DNA profile that was under Maggie Murdaugh's thumbnail. And so the court was asking them, how long will this IgG DNA process take? And is there enough of a profile to even do the IgG analysis? So the defense needs to bring those answers to the court on August 14th. And then the court said, if the trial date needs to move a little bit, that's fine. But right now it is set for April 5th, 2027. And the court said very clearly to the lawyers, I don't do continuances. I don't do continuances. The trial date's the trial date. And we're going to go forward on that date. What court they're going to go forward in is up in the air because the court did let the attorneys know if they can agree on a change of venue, that the court would be amenable to that. And if they can't agree on a change of venue or the change of venue is going to be objected to by the state, we don't know if it will be or not yet, that the court would then decide what happens with it. But if this case changes venue, this judge will stay with the case. So no matter where it's tried, this judge is going with it. This judge normally sits in Lexington County, but if this goes back to Colleton County or to another county in South Carolina, this judge and everybody else goes with it. And then it becomes a traveling circus, not just one that is it is fixed in location. So we will be seeing the pretrial conferences in Lexington County, and then we will have to wait and see what happens with the defense motion for change of venue, the defense motion for DNA. There are some issues of protective orders. There is still an outstanding issue that Alex Murdaugh wants a laptop in prison. The prison has said no, but he wants to be able to go through his discovery. And I expect we will hear the defense bring that up more in the future because, well, Poot's already laying the groundwork for, but Your Honor, if we can't get him these The files, there's so many files. It's like 20,000 pages of discovery. It's not a lot in a digital case. It's not a lot of discovery. It's, as Creighton Water said, half a terabyte of data. It is not the most data heavy case that we have seen, but we already saw the groundwork being laid. But if Your Honor, if he can't get all this information, we're not going to be prepared to go to trial in 2027. We're going to need till 2028. And the court has very clearly said that there would have to be very, very, very good reason for this case to get continued. Oh, and we also learned, though we had heard in the past, I don't think we had heard in court because this case hasn't been in court, that Alex Murdaugh did lose his tablet privileges in prison and had contraband of some sort at some point. So it's not as if Alex Murdaugh hadn't stayed out of trouble in custody either. And so that complicates things just a little bit. So we'll be back in court for Murdaugh August 14th, 2026. If it's streamed together, we'll be there in real time. If we get the video after, we will cover it later that day or the next day. There was much going on in other courts. We are not turning our attention to them today, but we will turn our attention to them soon. We will see what happens. We will just see what we can do tomorrow. I will do my best. I will keep you posted in the lounge on what's going to happen tomorrow. For all of you who sent your well wishes to Dr. B, thank you. Back's just, things take time. So hopefully we will have some answers about his back. I will keep you posted about that. I'm going to try to answer as many questions as I can. I am not breaking up this name correct. Marina makes stuff. Hopefully I said that. Marianne makes stuff. What consequences has Courthouse Becky faced so far? Well, she got prosecuted for fuckery, but not for jury tampering. So she got prosecuted for fuckery, but not for jury tampering. So what consequences has she faced? She's on probation. So the answer is not enough. What consequences will she face? I don't know. I mean, Alex Murdaugh is suing her in federal court. We've been covering that. I'm going to keep covering that. I'm real curious to see how that goes. Murdaugh is suing her in federal court. That's going to be annoying and expensive for her to deal with. So, yeah, not enough consequences. Chloe UK said, Emily, do you think it will be 6 weeks like last time, or do you think it'll be a shorter trial? I think it'll be a pared down trial this time. I think it'll be a pared down trial. But if the defense are going to bring in more experts, we might see the defense have more time in their case and less time for the prosecutor. I do not think it'll be 6 weeks. Some of those very long court days were court days where the court was doing almost full days of voir dire outside the presence of the jury. I don't think we will see that happen again. And that took up days of court. We did so many witness voir dires that through a lot of that trial, it felt like we were watching, we were actually watching the testimony twice. And that took so much time. It took so much time. So I do think it'll be a pared down trial. Matt Bond, good to see you. Matt said, hello, my spiffy legal mumbo jumbo talkie sister from another mister. I've missed y'all. Good to see you. The dash in between. It's nice to see you in the chat. It's nice to see all of you in the chat. Big Dog said, we just had our first Buc-ee's open up here in Arizona. Fantastic. I hope it's exciting. We have a new Dolly Parton rest stop here in Tennessee that I have not been to yet, but I'm excited to go check that out. I haven't had a chance yet, but I'm excited. So it's going to happen. He gives Beauty for Ashes question, Emily, what makes some cases retried versus dismissed with prejudice? Why would a retrial solve the issue in this case? It seems like the publicity would make a fair retrial difficult. Good questions all. Dismissal with prejudice is rare. It depends on what the issue is. The discovery issue, the court decided in like the Baldwin case, could not be remedied. So the dismiss with prejudice was a discovery sanction against the prosecution. In this case, it's not being retried because of prosecutorial fuckery. It is Courthouse Becky fuckery. And the Supreme Court decided that Courthouse Becky's interference with the jury denied Alex Murdaugh of a constitutional right, a fair trial. Most times when we get to a case overturned on appeal, the remedy is a new trial. That is almost always the case. And here, that's the same. If you have a new jury picked where Courthouse Becky has not interfered with the jury, then Alex Murdaugh gets his constitutional right to a fair and impartial jury. Jury selection might take longer. They might have to change the venue. But in every high-profile case, they have been able to find jurors who know nothing about this case. You will be able to find people that did not watch the Murdaugh case, do not care about the Murdaugh case, have not heard of the Murdaugh case. And especially if you are in a bigger jurisdiction where people are moving into the jurisdiction or out, it will be easier. I think that might be really difficult in Colton County. Smaller county, it happened right there. There was much to do during this case. There were like food trucks out in the square during 6 weeks of trial. And those that didn't get picked on a jury might then have said, oh, well, this is going to trial. I can now tune into the case that I hadn't been following. I think in larger counties, it might be easier to find people who just didn't pay attention to this case or are like, oh yeah, I heard a thing about that. So we'll see. Cons the Dog said, how can he pay for everything? We have no idea. We have no idea. We have no idea. So it is, it's going to be interesting to see. EDB, how many years was Murdaugh sentenced to? I believe in South Carolina, it was 27. It's a little over 40. I don't know the exact number of months in federal. It was 200 something months, but it's over 40 years federal, 27 years state. Some of that is running concurrent. So 40 years plus, because there's some other stuff in that as well. But we're going with the rounder number, because once he's done with the 27, the rest of that 40 still has to happen. Michelle, happy birthday. Michelle said, I have birthday stuff to do, but definitely a great gift to have EDB stream. Happy birthday. See you on the replay, crew. Hope it is a great one. Let's see. The Hitchbot said, a bit curious, suppose he isn't convicted this time around. Are they likely to pursue other suspects or just drop the whole thing? If he isn't convicted, I don't know if they would. I don't think they have any other leads. If they do, they would have to be turned over and the defense would have brought them up. So if they pursued other leads, you would think that those other leads would be 8 or and better leads. By them trying him the first time and the second time, they think that he is the person who murdered Maggie and Paul. But I imagine that if he's not convicted the second time, the state's response to that, and of course we have to see all the evidence come in, but the state's response to that would be, this is a circumstantial case and the jury did not agree with our theory of the case. I don't think it's because they think that there would be another suspect. I think that the state would lean into, this jury didn't see it beyond a reasonable doubt, and then it would kind of prove the point of whether or not the jury tampering is a huge issue. But this will be a very different trial and there will be more things presented. So between, if he's not convicted at the end of the evidence in a second case, I will be curious to evaluate whether or not that is the jurors didn't see this beyond a reasonable doubt, like the state didn't prove their case, or did this jury think he was innocent? Because those are two very different things. And I think there are more situations that you can look at and say the state didn't prove this beyond a reasonable doubt versus, oh, they just they think that this defendant had nothing to do with this. So we'll have to see. But we're just going to have to take a look at the trial as it unfolds. And we'll see, because it's a circumstantial case, as many cases are. It's a circumstantial case with the weapons removed, but you still have, I mean, when you look at the first trial, you still have those kind of dominoes falling up into the day of the murders. And you have a pattern of behavior there. And then you have Alex Murdaugh lying about where he was until that one video comes out and shows that he's lying. And people are like, what are you doing? So we'll see. DK Cripple, good to see you. Is the death penalty on the table again? The prosecution, through the attorney general, who is, I believe, running for governor, said that everything is on the table again. This is a death penalty case. The state has not said if they are seeking the death penalty again. Could they? Yes. Will they? I don't know. I don't know. But also, if Alan Wilson is leaving office because he's running for governor, then that decision will be made by or I would think he would leave that decision to be made by the attorney general that's coming into office. So I think we would have to wait and see what the new attorney general does. Charlotte said, so wild that we're going to be watching this trial all over again. It is. It is. It's going to be wild to see, but who knows? Chuckle Squad said the software took a full glare from Murdaugh and froze. Yes, it glitched. He stared down the barrel of the cameras in court and my software blinked and went, nope, we're done. Ohio Palm Mom said, if IGG wasn't available, how was it concurrent? I don't know if I understand the question. I don't think went the avenue of IGG the first time that they ran the DNA. I don't know if they have enough information for an IGG profile. I think we're going to have to wait and see. Jumpsuit Pablo, thank you for the 5 gifted memberships, and everyone who gifted memberships today. Welcome new members. I appreciate you. Tanya Davis asked, can you explain double jeopardy when it applies? I can explain why double jeopardy doesn't apply here because we have the context. However, it can be difficult without doing a full law school treatise on double jeopardy. Jeopardy applies when someone is at the stage of the proceeding that jeopardy attaches. We will talk about when jeopardy attaches down the road more, but trial, when a jury is sworn, is when jeopardy attaches. However, when you end up with an overturning of a case like this case, jeopardy has essentially been wiped clean because the entire trial has been restarted. We're in a full mulligan mode. So jeopardy didn't attach because the last trial didn't happen because it's all been overturned. So you have to go back to where you were before that last trial because that last trial has just been like deleted from the record. There are different types of mistrial where even if jeopardy attaches and then there's a mistrial, you go back to the beginning and start over. But then there are things like the issue in the Baldwin case where jeopardy is attached. The mistrial is caused by prosecutorial misconduct. Therefore, it does not negate the jeopardy and the case gets dismissed. You can't retry them because jeopardy has attached and because the issue is caused by the prosecution. So here, it's as if he did not go to trial the first time. So it has been clean slated. Hopefully that makes sense. I'm trying not to get into a full treatise on double jeopardy. I hope I explained well. Part and parcel from seeing like Double Jeopardy, the movie, which actually does a pretty good job. RK said, I taught the Consequences song to my kiddos' summer swim team. They're all afraid of it now. When you stand on the pool deck going, look, here comes a consequence, consequence, consequence. I think we're going to have to put that on the soundboard. I think we're going to have to put that on the soundboard with this judge for this trial. I think we're going to need, look, here comes a consequence, consequence, consequence. Rose Sleeps says, it's fascinating. I think what's really difficult about Double Jeopardy is that it is kind of an intellectual fiction. And so there are times where you're just like, but Jeopardy applied. What do you mean we just like bippity bopped it out of existence? I know. It becomes kind of an esoteric intellectual hurdles where you're like, okay, but if you go down these hurdles, then you can't have another trial. But if you go down these hurdles, then you can. I think the clearest way to look at Double Jeopardy really is when you look at the way that without getting all the way into the founding of the US legal system, which is fascinating because our legal system is so unique and also kind of a hodgepodge of like, what do they do in England? What did they do in England? What do we want to change in the American tradition of law? But what do we pull from the English tradition of law? And the fact that we have state system and federal system really starts to become a big part of the problem, because you can be tried for something at the state level and at the federal level. And so when you're looking at one action, one shot, one opportunity, when you're looking at one thing or one crime or one whatever, you are at risk for being prosecuted for that at the state level and then prosecuted for that at the federal level. Or, depending on what you're talking about, you could be prosecuted at like the locality level, then at the state level, then at the federal level. So using Los Angeles as a rough explanation, within LA County, you have the LA County District Attorney's Office, but then within different localities, you have city prosecutors. You have a city prosecutor for Los Angeles City. You have city prosecutors for Long Beach, Hawthorne, etc., Santa Monica, Culver City. So you've got different localities operating within. So you have multiple different layers of prosecutorial jurisdictions. So if somebody gets a fish and game violation and the city prosecutor for a jurisdiction goes to prosecute them for a fish and game violation, they can't then be prosecuted for that same exact fish and game violation by the district attorneys and then by the feds. So you can't be prosecuted for the same thing each level of prosecution. Now, if there are different actions, different days, different things, yes, you can. But you can't be prosecuted for one thing on multiple levels. This also comes into play more if prosecutors do not charge someone with things they're aware of when they charge someone of like crime A. So somebody gets arrested, they're charged with crime A. Prosecutors are aware of crimes B, C, D, and E, but they don't charge them for B, C, D, and E when they charge crime A, but they know about them. You can't prosecute somebody for crime A, go, well, that judge gave them a stupid sentence, that's too light. Let's go back and get them for B, C, D, and E. You knew about them and those crimes at the time that crime A was committed. So that prosecutor can't go back and get B, C, D, and E. However, the feds might be able to then go and grab you if they are federal crimes and jurisdiction applies. But that prosecutor can't. So like with Courthouse Becky, they knew about Courthouse Becky's allegation of jury fuckery. They prosecuted her for perjury, the ethical violations of her job, theft and what have you. They didn't prosecute her for jury tampering. They knew about it at the time. They can't go back and say, well, we didn't charge it then, we'll charge it now. They can't just hold it in abeyance to like spring out at you later so that there's like a, oh, well, we didn't get you for enough time, so now we're going to put you in jeopardy again. We knew about it there. So it's easier to think about double jeopardy when we're thinking about uncharged crimes versus charged crimes. It gets a little more complex when we're talking about mistrials. But if the trial gets wiped clean like it didn't happen, then you don't have a double jeopardy issue. Hopefully that makes sense. And when you're looking at split jurisdictions, you also have, if the crimes are not analogous, but it's the same behavior, then you get into a really odd kind of quagmire about, well, the charges are different and the elements of the crime are different. So even though it's the same course of conduct, it's not the same crimes. And then it gets into a much bigger mess that we're not going to get into today. But we have lots of different levels of prosecutorial jurisdiction in the US, and that's where double jeopardy is really necessary. Let's see. He gives Beauty for Ashes, says, but what if they felt like they didn't have enough to get a conviction, so they didn't charge at the same time and then later felt that they did? It gets into very tenuous grounds if they were aware of the case. if they were aware of the crimes and if they charged for something. If they charged for nothing, you can charge later if you're not out of the statute of limitations, which doesn't exist in South Carolina. So just doesn't exist there. Which is odd. So we would see. Let's see. Would double jeopardy be removed and him retried if he had been acquitted, but the prejudice by Becky was against the prosecution? No. Wouldn't change anything. If you're acquitted, period. Period. If you're acquitted, period. There is nothing that can be undone. If Courthouse Becky went into the jury room, this is a total hypothetical. Total hypothetical. If Courthouse Becky went into the jury room and said, I saw Creighton Waters in the parking lot and he was talking to people and he said, oh, Alex Murdaugh didn't do it, but we're prosecuted. Fuck those Murdaughs. Am I right? And went back and told the jurors, the prosecution's all lying to you. There's not enough evidence. In fact, I saw somebody else do it. So y'all are going to convict an innocent man or whatever. And he got acquitted. And then that all came to light. You can't undo the acquittal. An acquittal is untouchable. It's why you see prosecutors fight so hard to correct wrongs at trial, because if somebody is acquitted, it does not matter what happened. There is nothing the prosecution can do to fix it. So if there is prejudice against the prosecution and someone's acquitted, tough shit. No appeal, nothing you can do. So prosecutors have to bring those things up during trial because they cannot fix it later. If you're convicted, there's always room for appeals. If you're acquitted, done. Period. Nothing else can happen. Even if they find, name the thing. Acquittals stand no matter what. So hopefully that makes sense. And hopefully that makes sense in the context of why you see prosecutors sometimes fighting so much over rulings in trial, because there's nothing they can do later. Like once the shit's out of the horse on that, there's nothing they can do. Stormy says, can Alex's prior testimony be used this trial? Only as impeachment if he testifies. If he does not testify, then no. Alex Murdaugh is back to having a Fifth Amendment right. So no. If Murdaugh testifies, they can use it to impeach him. So we will see. May said, or like OJ, who admitted in a book after the acquittal. Yeah. If somebody gets acquitted, they can go out and give an interview and say, I did it. This is how I did it. This is, well, you'll find everything. And there's nothing that can be done other than like a wrongful death trial. But there's no federal prosecution or state prosecution that can happen again. So yeah, back to the movie Double Jeopardy. If you haven't watched it, go watch it. Double Jeopardy is a great movie. So with that, law nerds, I have got to scoot. It is great to see all of you. I will keep you posted in the app. I very much want to stream tomorrow. I just don't know when that will be. It's going to depend on Dr. B and how Dr. B is doing. So we will see. A lot of you asked about my shirt. Give me 1 second and let me take a look before I say anything. Let me see if I'm looking to see if you can grab your own Lost Boys shirt. Because I am not 100% sure. Let's see. At the moment you can. Okay. Law nerds. Again, I'm answering the question. These are not through EDB. These are all through the Cavaliers. These are the Lost Boys shirts from the show for this year. And I will show you real quick on the screen that, and I will put the link in. Oh, my scenes don't want to change. That's fantastic. I will add the link in the bottom. The Cavaliers show shirt is available on their website, though these will also, if you're going to a DCI show this year, depending on which show you're going to, if the Cavaliers are performing, they will have a merch booth on site. They should have these all summer. So if you're going somewhere live to see them, you can go grab it. If you're going to one of the shows, I talked to their merch team. They said that they do not expect these to sell out. They have tried to make sure that these will last through finals. But if you are not going to a show this year, or you just want to make sure that you have it, they are there. They also, for a limited time, and these will sell out. Let's see, unless they've already sold out today, because they released these today. They have a very few diamond cutter shirts left. The Cavaliers have created their own rock bands the way that we did with the Hostile Witness shirts that then were all sewed wrong that are coming. We created our own band just like they did. I had no idea they were creating their own rock bands for their uniforms, but take a look at this. Their uniforms this year, hold on. Their uniforms this year have the different rock bands depending on which section they are. So different sections get to wear the different bands in their uniform. And it's like Emily's DCI minute real quick. It's like, we're going to take a break for Emily's DCI minute. So the Cavaliers created different bands to wear in their uniforms. A, I think it's rad, but B, copyright's a thing. So this is absolutely the best way to do this. But when you look at their uniforms, you can see that you've got, these are members, marching members. This shirt says G-Man in the four corners. This one says Spin Cycles. So the different sections have different shirts that they are wearing, and then they're showing those this summer. So of all their shirts, this one is my favorite. The Gears and Roses shirt is not available yet. The rose is one of the Cavaliers icons, emblems that goes back there from Rosemont, Illinois. So this is part of them honoring Rosemont. So they have the different shirts. Those are not all out yet. The only one they've released is the Diamond Cutter shirt. It has sold out in person. They've put them online. I am optimistic they will also put the Gears and Roses shirt online. I was told, I hope this isn't top secret. They know I'm a content creator. I have been told that the Gears and Roses is going to launch at Allentown. So y'all have the heads up. I do not know if it is going to be online, but I have been told it will launch in Allentown. Joe asked, did you get your nails done to match the Cavaliers kit? I 100% did. I 100% did. So they are called the Green Machine. And that's part of why we've got the Gears and Roses. I'm very excited. Gears and Roses is fantastic. So these shirts are launching throughout the tour season. It can't be that top of secret. I asked a question. They gave me an answer. If we can't tell anybody, it's going to be fine. We're building anticipation. So these are the shirts that are coming out. Diamond Cutter is the first one, which also is a deep cut in Cavaliers, well, not lore, but in Cavaliers formations. So the Diamond Cutter is actually a formation. G-Man in the four corners, Spin Cycles, and Gears and Roses. For those of you saying Allentown, PA, yes, Allentown, PA. So love that. For those of you asking which band is T in, T doesn't get a band shirt for guard. I will show you what T is in for guard. I think I have a picture of him in uniform. I do not have a great picture of him in uniform, but hold on. I have a few pictures of him, and then I've got to go. You can also follow the Cavaliers if you want to on Instagram and Facebook. Let's see. I'm just pulling up the color guard photos. I think I have some pictures of T in uniform. I have a lot of pictures of T not in uniform, but I don't know if I have any pictures of T in uniform. I will try to find one, but this is an entire post that one of the photographers, Cameron Elder, posted yesterday of the Cavaliers guard. Let's see if I can. I see a lot of purple hearts in that comment section. I love it, but this is a lot of Travis. That's my kiddo. I love the black and white photos, but that's T. Yeah, things Brian can't do at the moment. Things I can't do ever. But that's T. And that's T in flight. By the way, I told you all about the Buc-ee's shorts. I'm not lying. I told you all about the Buc-ee's shorts. The Buc-ee shorts are a whole core vibe. So that's T. Let's see. I know this performer's nickname, but not name. But they are right next to T in most of their performances. That's T. Told you. Just all the Travis. All of the time. Lots of Travis. Hold on. I can do that. I think I can do that better. There we go. And that's also Travis. Covered in pellets from the AstroTurf. So those are all at Adrian College. The Cavaliers do love a backbend. They love a off access. Travis is doing a lot of dancers, a lot of dancing this show, and I love it. So lots of Trav jumping. Trav has a pretty good leap, but yeah, he's been running around all summer with no shirt, so that when he has no shirt on in his uniform, you can tell. Let me see if I can find one. This is the guard. The guard has a couple different uniforms. This is Devin. He's their lead performer. Devin's in his sixth. You heard me correct. Sixth DCI season. Devin is an incredible performer, amazing dancer. You won't miss him when he performs. If you guys saw the Cavaliers show last year, Devin is the one who did the tumbling run to start the beginning of the show. Absolutely incredible performer. CCG has beautiful performers. Devin is just, he is one of those performers where your eye just pulls to his performance. Just a gorgeous performer. And so the guard, you can see that the guard uniforms are just slightly different than the core uniforms. And they have jackets that sometimes become props, sometimes don't. Aren't they great? Aren't they great? I know. I'm geeked about this show. Let's see if I have one of Travis in uniform. I might. I have lots of Travis jumping about. I don't know if I have nearly as many. Let's see if I have any saved that have him in uniform. I told him the other day, because I did not get a picture of him. I did not get a picture of him in uniform at Adrian, because they changed out of uniform before I went and tracked him down. I was trying to be cool. I was not trying to be all uncool. I was not trying to like run down on the field and be like, I need a picture. And now I don't have a great picture of him in uniform, but I don't know if I have. I will post one if I find it. Let's see. But I don't think I have one. I think I have a very rough. I don't know if this one has the guard in uniform. Let me see. I'm looking through a few old photos from Instagram, and I don't see it. I'm going to look one more place, but I was trying to not be like that mom and just go running down on the field and be like, I need a pic. I was trying to wait and be cool, and then I missed my opportunity. He's promised he will send one. We'll see what happens. Let's see. I can probably show you their pre-show, and then you'll see Travis in uniform just a little bit. But I think I can just show you the pre-show, because the pre-show is, or should not be, copyrighted music. Give me 30 seconds. I had one on Insta. I did not grab it quickly, and I'm trying not to do any. There were some moments of the show I very much do not want to spoil yet, because there's only been the one performance, but I can show you the pre-show, and that would work. That would work. I don't know how loud this is going to be. All right. Some of the pre-show. This is them. There will be cheering, but this is them taking the field before their performance of the Lost Boys. So, Travis, let me zoom in real quick. I don't know if I do later in filming this. I'm going to zoom in on computer. Travis is here. So that's Trav up on that prop. So you get a little sense of his uniform up there. So that's Trav on that prop. Oh, I do zoom in. Okay, now I can zoom out. So that's his uniform for their pre-show. Their pre-show's a vibe. And when I say pre-show, this is not their show yet. This is them taking the field for their show. This is the walkout. So, there's T. That gives you a sense of the show a little bit. Yep. So that's them getting all into place. I know. So that's the walkout vibe. And that's T bopping along on the top of a prop with a trumpet. So that's his uniform. Yeah, that's his uniform for the show. I love the creative direction of this show. I really do. I also love that everybody's into it. I mean, you've got to be. It's all or none. I love it. But this show's a vibe. I enjoy it a lot. I will share some other parts, but he's on a prop a lot. If you give my kid the opportunity to be on a prop, he's going to be on a prop. Last year he was on a prop. This year he's on a prop. There probably aren't any of this online. There are a lot of copyright considerations when it comes to DCI. I mean, with all performing arts. But if you do find it online, somebody will invariably call it totally not the Cavaliers 2026. Because there's also quite a tradition of folks posting the videos online, calling them totally not this performance or that performance within DCI, but they have not performed on Flow Marching yet because their Muncie got rained out and it wasn't being filmed. And then this is just their home show. So we'll start to see some different shots of that. I will let you know. We are and should have a discount code for you for Flow Marching. I will keep you posted on that in the app, and then I will take a look to see which of their next performances will be streamed, and we'll go from there. So we will have a link for that, and I just don't have it yet, but I will have a link for you for Flow Marching if you want to watch that streamed. You do need to catch most of those live because they don't always have music rights for replay, but do have music rights for live streaming. When we have to get into sync rights and music and composition and performance rights in stadiums, it becomes a whole thing. So with that, I think we are the only ones with any Flow Marching discount. And so we will have that for you. I just need to make sure it is activated, which was on my list for yesterday. And then I spent the whole day at the hospital. So I don't have it yet, but I will let you know. However, I will say, though not by me, there will be those that will post these on, they will post them on the YouTubes. So you can probably find them at some point. So that is that. And with that, Law Nerds, it is great to see you. I've got to go get everybody to appointments. I appreciate you. You were the best. Law Nerds, it's always good to see you. I'll keep you posted in the app about tomorrow. I'm just not sure what time. All right. With that, Law Nerds, you were the best, and I will see you soon. Have a great one. Thank you for putting putting up with the scheduling changes, and then the tech issues today. Today's been an adventure. We're going to roll the outro. I'm going to see you all tomorrow. Thank you for your patience and all the well wishes. I'll pass them on to B, and I'll keep you guys in the loop on how he's doing. He'll be okay. It's just a matter of how long it's going to take. Because life. I'll see you guys soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.